Yeah. All right, well, it is 10 o'clock. I will go ahead and request that we actually begin this meeting and call the meeting to order.
Excuse me, Chief Staff Eric,
Here.
Assistant Chief Jessica Anderson,
Here.
City Manager James Devlin.
Here.
Lieutenant Clifford Drake.
Here.
Garcia.
Here.
HR Director Christy Lewis.
Here.
Mr. Robert McKay. James Carmel.
Here.
Captain Dennis Bryce.
Here.
Chief Victor Rodriguez.
Here.
James Messer.
Here.
Christian McAfee.
Here.
Deputy Jason Warren.
Here, ma'am.
We have a quorum.
Okay. So I believe you communicated the changed minutes. You communicated that to the entire group.
They're available for you to see.
Okay, so if everybody would look, apparently it was correction from the one that was previously sent. You know what the correction of note was? First,
Section recommended that we move
Oh, right there.
forward. Minor. edit. And I incorporated your two.
good. So seeking a motion to approve, and second?
Motion approved.
All in favor, signify by saying aye. Any dissent? So when Greg gets in here, we will pause briefly so he can introduce himself. I don't know if everybody knows the new TSL director, but get to know him a little bit. I'll be here shortly. And Dennis, if you can't hear us, just hey, speak up real quick and say, hey, can you speak louder, et cetera.
Y'all are fine. I hear you fine.
So we are going to have to muddle our way through these three best practice policies. Ideally, we would finish these today with the presumption that they would go to the commission in the month of February for final adoption on before March 1, 2024. Correct?
That's correct, Chief. And just in a note on that timeline, they would go before the commissioners in late February for the commission meeting as presented. And then it would go for further public comment in the Texas Register and final adoption looking at April after that public comment period for being posted statewide.
So would you see that there would be any comment from the commission and or the public that would necessitate changes, which would then occur in the month of March before final adoption in April?
Not until April. There would be no changes that could be made until the April meeting. That's correct.
With the commission?
With the commission, yes.
All right. With that, John, take it from there from the staff perspective.
Sure. Good to see everyone again. As you said earlier, Chief Stevens will join us in a few minutes. We'll welcome aboard the advisory committee process when he gets here. Also of note, you may notice Director Grigsby is back after a fairly lengthy, I guess, November, October, the last time we saw her here with us. It's great to have her back.
Appreciate you.
It's good to see everybody as we move forward and as we move toward getting all of our documents and all the work product of the committee finalized and moving towards final adoption sooner rather than later. We appreciate all the work y'all have done and the way it looks after reviewing everything and based on the feedback we've gotten so far, at least internally, we look forward to having this wrapped up by the end of the month. Is what it looks at is based on the work that you all have put in and how far down the road we've gotten. And we really appreciate that. So thank y'all.
I know we have a couple of guests who are also, I know we have a chief here and I haven't met you, sir. So would y'all introduce yourselves, please?
Lieutenant Manuel Jimenez from the Austin Police Department, the people coordinator for the academy.
Awesome. Welcome. Chief.
Daryl Gibson from Big City of Corian.
Welcome. Thank y'all for coming. Did you want to introduce any of the staff on the outside?
Who do we have here? Let's have everybody introduce themselves. Let's start with you, John, in the back.
Just John, just working in the IT department for TCOL. If you guys have anything you need help, especially you, Rice, on the other end. If you need anything, can't hear us, let me know. I'll help you out, okay?
Aaron?
Aaron Heath, Assistant General Counsel at TCOL.
Iris Martinez, the legal assistant here at TCO.
Jessica Capella, Chief Information Officer. Gretchen Grigsby, Government Relations Director.
TJ Vineyard, I'm over the Enforcement Division.
Jenny Hobig, Assistant General Counsel.
Abigail Sunley, sorry. I'm the newest legal assistant.
Alyssa Tola, Legal Assistant.
All right, any remarks, Jessica?
No, I'm excited about today. Ready to jump in?
So I've been giving this some thought. As we work through the proposed suggestions, because I've got a lot of suggestions. I kicked it to attorneys, I kicked it to chiefs. Jessica did the same thing within the TPCA circles. Many of you then sent me critique, feedback. I want to be mindful that we've got to be sure to codify the requirements of the law. So I almost need an arbiter who's going to say 1701 requires this, 1445 requests this or requires this. Who is the best person in here who can keep us grounded on what it shall contain? Looking for a volunteer. I have all of the 1701 and then 1445. I didn't print, but we can probably access it in emails. So does anybody feel like they want to be the stalwart for law?
I mean, staff side, I think that'd be a perfect role for us, Chief. That,
Okay, good.
yeah, we're neutral and just making sure we stay within the confines of 1445 and we'll move forward with that. Be glad to do.
Good. All right. So does everybody want to probably begin with the misconduct sample policy? All right. Iris, I believe, passed those out.
Can we actually start with hiring procedures?
We can absolutely start.
Only because I feel like there's a little bit to discuss, and I feel like I need a warm up.
Okay, this is gonna be a great day. All right, so
Thank you.
my document shows that it is 3 pages. TJ did the initial draft on this. It has a lot of the red language, which I believe we added after our last meeting. And so let's begin with page 1. Did any of you all receive feedback on proposed changes for page 1 of the hiring procedures model policy?
I have two questions on page 1. The first one, this goes for both the model policies. Do we want it to state in the policy that this is a statewide model policy adopted? My thinking is that as chiefs change or as staff change, that they need to be aware that this is a model policy adopted statewide and that changes need to be consistent with those recommended. They don't think that they can go in and edit or change or remove this.
So that would probably be underneath the introduction.
Yes, sir.
Agree. So your recommended verbiage would sound like?
I don't know. The content, not the wording.
I think, Gretchen, correct me if I'm wrong, but we did something similar when we did the model policies last session. I think there was boilerplate language to say that this is a model policy. You can exceed the scope or whatever.
Yeah, and
I'd be able to pull from that.
right, and if there's not something in there, and I think you're right, but we can work on something like that and shop it around. That shouldn't
And
be
that would
difficult
be-
to achieve.
Preferable that it's the same in every model policy, right? That they can tell it's the same language came from the same source. And then my only other suggestion, that first paragraph in our background investigation, number 3, ends with Texas Occupation Code 1701-451 or 1701-451A. Restricting it to 3 leaves out a bunch of the important stuff, so.
I'm sorry, can you say that again?
It would make it Texas Occupations Code. And then at least strike the 3 or strike the A and the 3.
So I added the occupations code just as a citation reference for us as we're working. If we want to leave those in, we can. If we want to just remove them, we can. I just thought I'd put them there initially, so if we were discussing it, we knew where to go.
So that's an even better discussion, maybe. I'm generally against citing statute because the statute can change, right? And then you have to update your policy, but I think this one's pretty important and it's a good reference for anyone conducting background investigations to know where in the occupations code to go. It may be worth leaving in there.
So you specifically want 1701.451A and 1701.451A3?
Just strike the 3 so that we get all of subsection A.
A. So for everybody's knowledge, A says, before a law enforcement agency may hire a person licensed under this chapter, the agency must, on a form and in the manner prescribed by the commission. This goes through all of the stipulations associated with what you're going to do. It's really pretty, it's 2 pages of statute. That's what you're asking for inclusion of.
Right, we would want to point
It's a
them to that
statute.
whole section, not just the 3, right? If they really need to, for this section, they need to read all of A.
So I think what TJ is suggesting is including the citation, not necessarily the language there.
Yeah, totally agree with
Okay,
that. Yeah,
okay.
no reason to repeat.
Okay, making sure.
So there's a motion on the floor that says, at a minimum, the background investigation shall include the reviewing the following, and in parentheses, occupations code 1701.451A. Period. Any dissent? All right, you got it? All right. Any other recommended changes? On page 1, I'm still going through all of my notes because people sent me all. I didn't. Y'all just gotta bear with me because everybody sent me these things. I want to be representative of their concerns. Dallas, were any of these two related to this policy? Personnel files, we're doing hiring. This one is personnel file. Either one of Dallas's are related to this policy, agreed? Here. While I'm looking, did anybody else have one?
Yes, I have one.
Okay, good.
This is from my legal office. For A1C, 10 days there. They asked that you clarify if whether or not it's going to be business days or just calendar days. This term. Business days. So under section 3, background investigation, A1C, if a release was provided, an agency does not respond to a file, hearing request for records within 10 days. Is that the section we're talking about? That'd be 10 business days.
The agency requirement to respond to a TSS request.
Right.
Is that in rule or is that just a?
I don't think, I'm not sure that rule or statute specifies a.
Within 10 business days.
We can add business days.
So the recommendation is to turn it into business days.
Yes, sir.
Would that be under 451?
Looking.
The other
So
two?
the 10-day requirement is what we ask agencies is a reasonable expectation to wait to get those things back before they proceed and note that the agency didn't respond. But there's not a rule requirement for those agencies. We follow up with those agencies, contact them and take steps, but that 10 days is not written in rule right now.
So you want it to be business? Business versus calendar?
They were just asking for clarification.
Oh.
Because it's going to be presumed, the way it's written, it's going to be presumed it's going to be calendar days.
Correct. Without saying business, it is calendar day. So it's obviously, we don't have anything in rule based on staff's recommendations. So if y'all want to enlarge it to business days, certainly the committee can do so.
Seems reasonable.
What do y'all want? Business. Business. Any dissent? Mr. Iris, we're gonna make the recommendation on page 1, 3A, C, that it be within 10 business days. All right. Anything else on page 1?
This is really minor, but on page 2, I refer to it as Texas Occupations Code. So we would want to do that under 3 to make it Texas Occupations Code or strike Texas on the other page, just be consistent.
Where am I, TJ? Say again?
Back on the Occupations Code reference we have right under number 3.
Yes.
On the next page, it's referred to as Texas Occupations Code 1701-451, so we just need to be consistent, make a match. Put Texas on the first page or strike it.
I agree. Ours on page 1, under section 3, under the main bullet, just make it Texas Occupations Code.
And then also under 2. 2 has occupations code as well.
To what's that?
2B, the very top there.
So Chief, if we can, just throughout, if we can have the citation to is, if it's my understanding, we want it to be fully Texas Occupations Code spelled out, not necessarily citation. We'll make that note for consistency throughout. So.
It's a non-substantive change we can work on formatting once.
Correct.
Okay, good. All right. Any other concerns on pages 2 or 3?
If I have a question maybe for staff or another department here. Under the fingerprint check returns, it says a copy of the fingerprint check return shall be maintained in the personnel file. My department told me that CGIS has a little bit of a problem with physical copies of the fingerprints being printed and stored, and that we work through that with CGIS, but just wondering if there was any direction from staff or other agencies on how to navigate that.
We just went to a TCO audit and I've literally looked at all of our employee files and I don't recall ever seeing any save pinprint cards, period.
Well, this would be the return.
You're talking about the fast return, right?
Correct.
Oh, okay, okay. How else would you prove compliance?
That's what I don't know. Just print that. CGIS doesn't like it printed, but to prove compliance, you have to. Is what I
But you don't have to. You can digitize your record, so you could keep it digitally.
Correct, but I guess they treat it the same, whether it's stored digitally or physically.
There's the record.
So maybe it is what it is. I just wondered if anyone has any direction on how to navigate that. If we can give clarity. If not, it is what it is.
Chief Stanbridge,
Go ahead, sir.
I'm with TJ there. I recently went through a CGIS audit and a TCO audit and had the same issue that he spoke of with CGIS. They got all bent out of shape that I had the digital copy of the fast return and I had to talk to him and said, that's a TCO mandate. And he says, oh, I know it's a TCO thing. He says, shouldn't happen. And so then when David came through to do my TCO audit, he mentioned that he was going to reach out to Austin and say that CGIS and TCO need to figure something out. But he most definitely, it says you're supposed to have them in your file. So we left them in our digital file as well. So we had the same issue fighting that battle as well.
So from staff's perspective?
Let's circle back on this one. We'll get that information that we need on that. We can resolve that probably here pretty shortly. But what I'd like to do is, Colin, I get with him because he's in charge of the credentialing and FSAs. I want to make sure that we're on the same page, but absolutely. Let's make a note of that and we'll come back to it. We'll have a resolution today.
Yes, sir. Thank you.
Want to add that as an action item then? Okay. I have a question from a person who sent me feedback. This was a philosophical question that he was asking after he reviewed the policy. He said, after dealing with literally hundreds of backgrounds now, I can tell you that most of us trade documents regularly using encrypted emails as it is much more efficient than the TCOL secure share. I believe this policy still allows for this, as it says, such as. I want to make sure that we protect that option. Don't get boxed into only using secure share. Survey says,
Read it like it was written. We strongly recommend secure share. It is an encrypted portal. We can be sure of the security. They're taking the responsibility on that way, but it is not prohibited.
okay, so does anybody know in this specific policy where that is? Page 2 or 3?
What he's talking about,
Yes, where he's talking about.
it's on page 1.
Yeah, it seems discretionary. I don't think the language needs to change. Do you? He perceived it as discretionary.
Unless there's confidentiality issues with them sharing emails, you know, and not just using secure share that we know is confidential.
I feel obligated to speak up and say if very sensitive personnel files are being shared through email and the email is not encrypted, which most users do not do, then they are potentially, that's data loss. That's called a data loss incident. And that we can't protect that if they're bypassing our system.
Okay,
So
that is not encrypted.
If it's not encrypted, but then at the same time, beyond that, the transmission of the data itself, now you don't know what they're doing with that email. How long are they keeping that email? Is that email now subject to open record? Is that email getting printed? There's a lot of, the containment of the data is now not contained in our system.
So you're saying it would be a best practice to solely use TCO Secure Share?
We recommend it.
Dallas?
Yeah.
Houston?
Yeah. Use secure care. Secure care.
That too.
I think it protects the officer's information. I don't think that they should be emailing out that type of information without going through a confidential database. I would agree with the staff.
I'm good with that. I especially the open records point. An agency that's not as familiar, something is sent via email and then now they don't know to not share that in an open records request.
Hey, Captain, you do a lot of these. Are you okay with just exclusively using Secure Share?
Yes, sir. That's all. The only way my staff does it is either secure share or face to face. And I think that's the only two ways that you should do it. I would agree.
how do they handle the hiring of officers who previously served out of state?
Honestly, we have not had that being a major issue. With what we hire, most of ours are pretty well locally, so it's not a major issue with us.
We hire a lot of out of state. Just hired 5. So in that case, you're saying that they couldn't send us their files through the TCO Secure Share because they don't have an account. Is that correct?
You have to go ahead.
Introduce the first obstacle. What says you?
That was one of the requests from my recruiting folks too, was to allow access to secure share from out-of-state folks because it's so difficult to get those records from them.
Yeah, in order to allow, there's some conversations we need to have on our side, I think, logistically.
I think for the purposes of the model policy, and I think what we're discussing here is definitely the better thing to do, ensuring confidentiality of records, is to use secure share. However, thing to contemplate is, does the statute or any rule or anything of that nature require the sole use of secure share? That's my question to staff. And I don't think the answer is yes. While we agree that's the most secure, best practice is to use that, but I don't think there's anything in statute rule which says that is the exclusive method for which you have to use. I just want to make sure, and I think it's a great discussion to have, but I don't know if it's, I don't necessarily know if in the model policy, if it contemplates going that far, prescribing a specific exclusive method for sharing records.
Would we be well served by just adding a simple provision such as through the secure electronic file sharing system provided by TCOL, which is strongly encouraged for confidentiality purposes?
I think that would be great.
Mm-hmm.
Or another,
You all fix,
another secure and encrypted. I mean, I think Jessica might be able to give us language on what the expectation
I
would be.
think we just keep it simple
Okay.
and stick with what Danford is suggesting.
Chief, you said, can you repeat what you said?
which, comma, after TICO, comma, which is strongly encouraged for confidentiality purposes.
Whose comment was that, chief, or is that anonymous?
Oh, it was my commander that does all my hiring.
About the exchanging emails? Okay.
You good, Iris? Yeah. So we're on still page 1, 3A, number 1, after the word TICO, comma, which is strongly encouraged due to confidentiality purposes. I'm curious, I don't do this stuff at all. If you send it via a secure and on the receiving end, they don't have security at all. How's it, don't you have to protect on both ends?
Yeah, it's protect encryption in transit and encryption at rest. So you probably have something within your network that does encrypt your at-rest data. But you know, if you take your laptop away from your network, or you're not on VPN, or it's on your phone and you have access to, and your phone doesn't have encryption. So yes, there's considerations with the at-rest data as well.
Did not know. Any other thought, questions, or concerns on hiring?
I'm saying we go out of state. Our guys will go out of state to do the backgrounds, but we're a large department.
Go out of state too.
They physically go and review the records.
Yeah.
On pages 2 and 3, the admin rule references, were those just for working, or did you want to leave those in?
Certainly we could remove TAB. I'm kind of indifferent about the references to the TICO admin rules.
Again, it's one of those things I worry they change and then everybody's adopted a policy that doesn't match our rules. It seems simpler just to strike the rule references. And on page 3,
Well, hang on, let's decide on that. So I assume you're looking at the bottom of page 2 and at the top of page 3, also throughout page 3.
right, it's 6, 7, and 8.
Do you all want to remove
In the titles.
the parentheses sections that refer to the admin role and tab? Got one, sure.
Yeah, Keep it consistent too. You don't have that.
But yeah,
Any dissent? No dissent. All right, we'll scratch those. All right, so we're gonna scratch on section 6, section 7, section 8. I don't see any others. Do you? Anybody? Let's go. What else?
I don't believe I have anything.
I go back to 3A1 where we just wanted,
3A1, go.
says parentheses said if previous law enforcement was agreed. Why is that?
Because that's in the law.
It's in the law. There's good reason.
At the top of page 3, the very, very top in C, it says physically sign the L2. I think we struck physically on the L3 because we just wanted to create the possibility that it could be signed electronically. So we would want to do the same on L2, just says we'll sign the form.
So your recommendation is, we're at top of page 3, section C, if the applicant successfully passes the medical examination and drug screening, the provider administering the exam shall sign the L2 form.
Yes.
So that would be digitally, physically, et cetera. So redact the word physically.
Yes.
The L2 shall be included in the employee's personnel file. Is there any dissent? I love discretion, so that's a good point. Should write policy for a living.
He does.
Oh, see? Good eye. Any others?
One more thing, Chief. 11A, applicants will initially be hired on a provisional basis of a minimum of 45 days and a maximum of 90 days. I know that we decided to give departments some discretion and some latitude on what they want their provisional hiring period to be. But should a department not make that decision in the beginning, what I don't want is a department adopts this model policy basically as written. And on a case-by-case basis, this applicant is given 45 days, this applicant is given 90 days provisional hiring period. Should we specify that the department has to pick a number between 45 and 90, or should we narrow that scope a little bit? I just don't want, if a department who doesn't know the background of this adopts a model policy as written, that they are looking at on a case-by-case basis, establishing that in advance.
So another book you mentioned, there, to what extent is a department who doesn't really deal with this a lot going to confuse provisional with probationary? And they're going to think that you're now stipulating what their probationary period is.
How does that stipulate what HR?
So-
What their, the city, municipality, county, whatever is considered to be a provisional.
I was concerned about B, so we might want to agree on the concept and that might help in the cleanup. I think the purpose of this section is that if someone previously worked for another agency and there's an allegation of misconduct, they have time to complete that investigation and provide you the information. Right. So, and I don't want that to have to go through TCOL because we're in a narrow time window anyway, and that's going to add time to it. They should be waiting to get that directly from that agency as well, right? Because they've requested that information. We're just waiting for it to be completed. That agency has the additional requirement to provide it to TCOL. So we might just make it clear if an employee is hired and is under investigation for any allegation of misconduct at a previous agency, their employment will be provisional for 45 to 90 days until they receive and review that completed investigation from the prior agency. Just kind of clean it up to show what the purpose is and then what they're going to get back.
Iris got all that right.
The recorder.
What if you changed hired to licensed? I mean, because I can hire somebody who doesn't. That's what we're dealing with, right?
No, they could be licensed when they come to me as a lateral.
Yeah, I'm just trying to wrap my head with exactly what TJ's saying, because I got a 12-month and an 18-month probationary, then you got a provisional, which is going to confuse
I agree.
a lot of folks.
And this is just giving you a period. If you hire someone who's previously been employed by another agency and left while they were under investigation for an allegation of misconduct, that hiring is provisional for at least 45 and up to 90 days until you can receive and review the report of the completed misconduct investigation from the previous employing law enforcement agency.
Right. How do we put that in there? So
Kind of like
the chief in West Nowhere understands that first provisional.
And that's the trick. That's why I was saying attaching it to what you're trying to accomplish might help clear it up.
Are we required to have this in the policy? Provisional hiring? We are.
Yeah, it's in the bill.
It's in, yeah.
Is the language of the bill, Gretchen, is that helpful?
Not really. It says establish a provisional hiring period of at least 45 days for any license holder employed by a law enforcement agency, et cetera, et cetera.
This is exactly what TJ said.
So you're an attorney, correct? So you wordsmith for a living, correct? Could you wordsmith this in real quick? And we can move on, but we'll wait until
Why don't
you're.
we do it on the next break and then we can move
Okay.
on. We can bring
Make
back.
a note
after
and
the
we
break.
can massage it.
Wordsmith.
Yeah, right.
Go, Jenny, go.
All right. That's a really good point, though. Thank you. That's a good catch. All right. I want to be thorough. Has everybody had a chance to contemplate any suggestion? Let me go through my records one more time to make sure I honored everybody's inputs.
And the recommendation.
I have one formatting suggestion.
Go.
It's 3A4. A.
Certain things that.
A.
Typically, yeah. Typically, if you're gonna have
That if what
A down below, there has to be a
They come up
B.
with is
Yes, I agree.
And so
how we'll deal with
I
that.
think the best option is just to delete the A and put it up with the rest of the four.
Very good formatting catch. Can't believe TJ fell for that one.
It's required.
Chris, did you catch that?
Right there.
Uh,
4 up to 3, or 4A, delete the A, just move it into the 4. All right, so we're gonna delete A.
And once we get there, I've got a bigger picture, something to keep in mind as well, once we make those changes.
I don't know what that means, but okay.
I'll give you time to make the changes, chief. If we're there, let's look at section 7. And this is just more of an informational, something to keep in mind as we move forward. Keep in mind, we also have a fit for duty review committee going on as well. So in appreciation of what we were discussing earlier is about conflicts and things of that nature, this will make sure that section 7 and the fit for duty, any corresponding changes that they make that may affect this, we'll keep you all abreast of that. So we're in
6 and
conform
7.
6 and 7. So we're in conformity with our own model policies. Just want to get everybody heads up on that. There may not be any, there may be some, but just aware that we're keeping track of any changes that may occur either like.
And this section 7 also applies to TCOs, correct? TCOs undergo psychs.
Yes, all TCO licensees.
We agreed, I want to make sure everybody in this room remembers that we agreed that under 7A, even if there's not greater than 180-day break, we wanted everybody to undergo the psych. Big departure from the norm.
Thought we were pushing that to the other committee.
Well, the way it's written, before being hired, each applicant must undergo. It doesn't talk about unless you've had less than 180-day break.
The other committee is contemplating that question, correct?
They've discussed it, yes. I didn't mean to interrupt you, TJ.
No, I think we're talking about the same thing. That's why we bring up this reference to 7. So for example, A restricts you to a psychologist or a psychiatrist. There is a provision that allows medical doctors to do it in certain unusual circumstances. The other group is discussing, is that really needed? Should we do away with that? They may end up in the exact same place that this group is. I just want everyone to be aware that if the recommendation is different, we need to resolve those differences. And since that is the focus of that committee, we need to bring that back to this group. So I just wanted to make sure everybody understood that even if we make this final, there could be a conflict that arises from that.
I would want to hear their recommendation
For the 180 or the medical.
for the 180.
I don't, they're not wildly different than what you're doing. There's just the potential that there could be minor conflicts that we would need to iron out.
If that committee recommends something that is different than the administrative rules, how is that resolved? Like removing the 180 or?
That's going to have to resolve in favor of the admin rules, but.
It was something that the
And it's something
commission,
ultimately with commissioners, if they, let's put it to you this way. If the model policy says, hey, we have a recommendation that is different from the admin rules, assuming that power only in the admin rules, then certainly the commissioners can amend the admin rules to follow the model policy.
Would it behoove every people and each of the committee chairs to have the meeting with all the committee chairs and TCO before we step in front of the commission and make changes that conflict within our own division?
Certainly within the realm of if the chairs wanted to get together and compare notes, absolutely. To the extent that we can involve commissioners in that, then that's.
No, they would be after that meeting.
Yeah, absolutely. No,
I want to get up there and say anything that then conflicts with the next committee member
no, sure.
who's going to get up and testify completely opposite of what I just said.
No, I think that's a great idea.
There's wisdom in that, it's like a workshop.
Yes.
Push everything together.
it's a good idea.
I will tell you that particular issue did come up in the courses of discussions last session. And so ultimately, the statute did not change at this time. However, We got another session coming up, and I think if the law enforcement community as a whole thinks that that's a change that needs to be made, then that's something that would be addressed next session in a statutory change. Just so that you're aware that that did come up.
Do I have discretion to ask an attendee in the audience who's a, as he said, a small-time chief? Chief, I have a question for you. What's being contemplated is, right now, the current procedure is, if you are going to hire a peace officer or telecommunicator who's previously licensed, and there's less than a 180-day break, you don't have to get a new psych exam. The recommendation is everybody gets a new psych exam because life changes over the course of life. And so you would be in your agency, your city would be better served by having a new psychological exam done on every new employee coming into the agency. What says you?
I wouldn't be against to see a psychological done every year the same way, even a physical. Because a lot of things can happen, marriage issues. I have a policy. If I feel like that you are undergoing a certain amount of stress, you're going for a psychological test. Because I've had one officer commit suicide and it won't happen again.
Yeah. Thank you.
And that's been a discussion in that group. There are more and more agencies that are requiring regular medical and psychological on their own. So.
And some of that is a fit for duty issue, but what we're talking about here is regardless of the break-in service.
It's currently permissive, so they can go ahead with the.
Absolutely.
Okay. I would like to make a formal request then that the new chairs, both of them, from each of the committees, meets with TCOL, presumably in the next couple of weeks, after they've had their final meetings, so that we can resolve any conflict within the committees before we go before the commission. I just volunteered you for another meeting. Okay. And perhaps reserve the right to bring any committee member with the presiding chairs. Chief Stevens, perfect timing. Welcome, sir. The floor is yours. Introduce yourself. No, we want you to. Tell us who you are and welcome to TCOL, sir.
Thank you. I'm Greg Stevens. I'm going right over there where she's pointing.
Floor is yours. Talk to us about who you are, sir.
Stan, I'm Greg Stevens. I'm the new executive director of TCOL, and let me first say how much I appreciate each one of you being willing to give your time to participate in this committee, and I know that I appreciate it. It takes time away from your regular job, and so it's important work, and I think that the state at large appreciates it, and certainly the regulated community appreciates it. So thank you very much. I'm happy to be here. I'm on day 3. I got lost walking over here because so far going through the building, there's been someone with me, and this was the first time. And Commissioner Moe was with me before, but I had to go to the bathroom, so she left, and then literally I've been lost for 3 minutes on my way here. Fortunately, someone poked their head out of their office and asked if they could help. And so in accommodation of them, they got me going back so I could go into this.
Achievement awards are coming up in June.
Okay, perfect. That's right. The achievement awards are coming up. We're doing that. So anyway, don't let me interrupt. I'm just here to listen and help and offer anything I might be able to add. So, thanks. Good to see you, Stan.
You too, sir. Commissioner, Chief, comments.
Yes, good morning, everyone. I'm Kim Lamo, and I have the pleasure and honor of serving on the commission. And I want to echo what Greg has said. This is such important work, and the work that you are doing is going to impact the citizens of Texas. They're going to impact our licensees, the agencies that some of us work for. There's just going to be such a profound influence and impact on the work that you're doing. And I very much appreciate, I know Stan Misconduct, I spoke about taking on this responsibility, and we tried very hard to have a diverse group of people. And when I say diverse, I mean different needs, different perspectives. We knew that there were going to be some challenges because when you do that, don't always agree on everything, but that's okay. We need to hear everyone's voices. We need to hear your opinions, what your needs are. That's important that we try to address as many as we can. Also recognize that most of us have full-time jobs and very much appreciate you making the commitment to serve in this role. And I promise you, the one thing I can promise you is that you're going to make a difference and you're going to have an impact. And just appreciate you very much.
Thanks, Chief. All right. I did forget that courtesy of TMPA, our friend TJ, that lunch was being provided by them today. So thank you for doing that. And
So Stan, on one thing on this 7.2, and we discussed this before. If you look at it, in A, it says they've got to be licensed by Texas Board of Examiners of Psychologists, psychiatrists or MDs. So don't they have their own certifications? So I don't want to say those guys are not going to be board certified under psychologists. They're psychiatrists. So I thought we looked up what their certification was. Is that right, TJ? That
I believe we did. I think it was either TJ or Colin had that information. I might have it in my notes.
That they're, I mean, if they're board certified as a psychiatrist, you know, Texas board certified as a psychiatrist, that'd be fine. Something along those lines.
Or you're just saying licensed by a Texas board?
That's what we want. We want for sure that they're licensed in Texas. I think we all agreed on that. It just specifically says here.
Right, so they just won't be certified by that particular board.
Yeah, they're not going to have that same license.
But the psychiatrist would be at the Texas Medical Board, right?
Yes, because it's their specialty.
Texas Medical Board. So we'll just need to add that. Texas Medical.
Yeah, I mean, because you get a board certification in psychiatry. I'll spend.
Staff, are y'all comfortable with that?
Where is the change at?
This is 7A.
But just saying licensed in Texas, satisfied is for everybody?
No.
No?
You could be, well, I think you'd want to board certify for MDs.
So I think it would be Texas Board of Examiners of Psychologists or the Texas Medical.
That's, yeah, for psychologists, that's easier because they've got their specifically in that, their PhD that has that examination license. For medical doctor, their doctor specialized in psychiatry, and typically they'll be board certified. So you could, typically you could be a psychiatrist, not board certified. So don't we think we want the higher standard of a board certified psychiatrist?
And Aaron, to your point, just being licensed may not be enough to reach that level of.
It's,
Yeah, I see. From its description, I understand what you're saying.
right. I mean, it takes several years of work before you can actually get a board certified medical specialty. I think we would want that standard rather than someone that's in the process of getting their board certification. Not saying that they're bad doctors, but they're not at that level yet. Texas board feels they're.
So to TJ's point earlier, the other TJ, would this also cover medical doctors if that committee wants to include medical doctors in addition to the other two?
I would say reading section A only if that medical doctor is a psychiatrist.
But what they're saying, that committee is contemplating is
Right.
they're not going to restrict it to psychologists or psychiatrists.
Say if they made that change, we would probably have to readdress 7A for us. But for the time being, I'm comfortable with just adding the Texas Medical Board if you're comfortable with that change. Because you still have to be, it says.
You could be in the Texas, you could be a certified doctor under the Texas Medical Board. You're a doctor.
Right.
That's one thing.
Right.
But to get the specialty,
a board certified psychiatrist, faculty that, and like a radiology or a neurosurgeon, their higher standard is to be board certified in that specialty.
So do you want to say psychologist or board certified psychiatrist licensed by the Texas Board of, well, we probably want to.
You have to say Texas.
I think we understand the intent. Well, let's look up what the actual terminology is that they
Yes.
use.
Whatever.
Please,
We'll work
just
on
add it, just add it in to make it clear. Sure. I don't give.
Psychiatry, I just looked up what board certifies Texas psychiatrists, and it says the American Board of Psychiatry and Neurology, ABPN. Doesn't give a specific Texas board. So, Gretchen, what were you gonna say? What was the request then? Recommendation?
That we can clarify the terminology and add that in there
Okay.
so that we're properly citing them.
All right, so Iris, if you'll just make a note on 7A. We want a specific reference to a Texas board to approve licensing. All right, James, good question. What else? Anybody else? Okay, I'm gonna make a motion then that we're going to adjourn for 15 minutes while staff works on the language for section 11 provisional hiring period. When we reconvene, we'll consider what they have come up with. See you in 15 minutes. All right, we're gonna go ahead and get started again. During the break, staff, I guess you all made enough copies for everybody. Did everybody get this? Thank you. So we're gonna go back to that same policy we've been working on, specifically section 11. And the recommendation from staff is that I assume all of that language be deleted and replaced with this. Is that correct?
This could be A, B, C, and D.
Okay.
Inserted that way. This is just trying to get us all at the same starting point.
So everybody has a copy of this. Please review it. Let me know if you have any concerns.
Chief, could you read that out loud so I know what y'all changed?
Oh, I'm sorry. Yes.
Or I could email it to them.
We're gonna email it to you. Dennis, would that work?
Yes, sir. Thank you.
Okay, perfect. It's incoming. I will provide a copy for the members in attendance here. Chief, I want to review this post in lieu of. All right, we'll give Dennis a second to read that and then we'll final motion. On it.
Nice.
Okay, just a quick.
I was just gonna say, I want to make sure that we don't tread too far into the misconduct allegations model policy in this section. I think these changes are good, especially the first section. Although it says unresolved misconduct allegation or misconduct investigation, I think I might like to leave it at investigation because that's kind of the point. And I do like the other sentence about this is unrelated to any other probationary hiring periods. I think that's good clarification.
Because the misconduct policy is going to mandate that they have to complete the investigation, correct? Right? That could stay aloft. So Jessica's point is applicants hired while the subject of a misconduct allegation, or just call it investigation because that's what it needs to be, right? And leave it at that and take out all of that other unresolved misconduct allegation or misconduct investigation and just call it misconduct investigation.
Yes.
And then you had concerns on the last sentence. Did you want to talk about that?
Yeah, again, I just don't want to tread too far into the misconduct model policy with this one. This one really is just intended to address the provisional hiring period for those who are the subject of the investigation after they've left someplace else, so I don't want to. Less is more, it feels like to me, as opposed to bleeding over into the other one, but that's just some thoughts that I had.
Yes, I'm good with that last sentence, either removing it or moving it to the misconduct investigation policy. when we get there.
So let's start then with the last sentence. Who of you would like to see that removed? All of you? All of you? Staff, counterpoint? You're good? All right, so we'll redact the last sentence. Now let's go back to the first sentence. Are you all okay replacing unresolved misconduct allegation and just calling it a misconduct investigation? Victor, James, everybody?
Yeah, well, you don't, unresolved misconduct allegation, misconduct, just misconduct investigation, right?
Okay.
Yeah.
So applicants hired while the subject of a misconduct investigation is what it will be. Iris, you good? Everybody else good with everything in between?
I still would like to discuss the 45 and 90.
Oh, yeah. Yes. So restate that point.
So just that if I'm a chief and I adopt this model policy as written, I might not have a set number between 45 and 90, and I treat them on a case by case basis. And I would prefer that chief make a decision on what that number is and apply that to everyone equally instead of adopting the policy as written. So maybe we can either pick a number. I know we discussed a number before, or just say hired on a provisional basis determined by this agency, but minimum 45, maximum 90.
I'll be devil's advocate. No two investigations are the same. So if the law is going to give me discretion between 45 and 90, why wouldn't I want to retain that discretion as a chief? Because if the previous employee agency is doing an investigation and it's criminal and it's messy and it's ultimately going to land in my lap, I need closer to the 90.
Sure.
Whereas the other ones that are simple may just be a 45.
Sure.
So why wouldn't I want to retain that discretion?
But the law says minimum 45. We picked the maximum 90. I just want us to pick a number.
Oh, we picked the 90.
We pick a number.
So we could, couldn't we just change it to 90?
Law just states the minimum of 45.
We could change
We
it
could
to
get rid of,
90.
yeah, we could get rid of the 45 and just change it to 90.
Or we could pick 60, or we can pick any number as long as it's minimum 45.
90 days gives me enough time to walk through most significant issues.
Use not to exceed. Assuming that you get the investigation. That's the other one that I worry about, and we discussed that just if you want to specifically say in B that you could choose to terminate them based on the findings or based on, their failure to complete the investigation or provide you the report. Just to make it clear that you have that option, but I think 90 days gives you a much better chance, right? If they haven't finished it in 30 days, that you can make a complaint, you can resolve it, still get it, maybe get 60 days and have 30 days to review. You don't know the city.
So you're saying, TJ, on the second paragraph, and simply adding a sentence, if the previously employed law enforcement agency refuses to provide the misconduct investigation, comma, the agency may choose to terminate the provisional employment based on those findings.
Right, you could, or you could just add it to the end of the sentence. It says based on those findings, or if the agency fails to complete the investigation or refuses to release the investigation. The one that I see that we've dealt with is officer-involved shootings. Those are the ones, if someone has been involved in an officer-involved shooting, I can't imagine the mess trying to get them to complete an investigation and provide you a report within 30 days.
Okay.
Yeah, that's the thing. I mean, I understand the intent, and now we are kind of bleeding into the misconduct allegation stuff policy, but it does take a long time to complete some investigations.
Especially OISs.
I mean, we can change that in the misconduct policy. And this, that's in our purview, right? Because right now we have 30, but
The law
that's
says
something
30, I
that
think.
I thought that we had the ability to, I thought we came up with 30, because that's something feedback I've gotten too, which
Misconduct?
the 30-day requirement.
Exactly.
That's a.
So that it has to be completed in 30 days.
Determination or whatever.
No. This, y'all are talking, you're talking about providing it. She's talking about how long do you actually have to finish an investigation? That is not in the law.
Yeah.
30 days would be unbelievable.
30
Yeah.
days after completion. That's what the law contemplates.
Yeah, but I get the center wrong, but that's second.
Yeah. All right, so TJ's contemplating, what do you do from a provisional standpoint if you can't get the investigation or if it's simply not done and it drags on forever? What do you what do you chiefs what are y'all gonna do with it?
A quick question though, TJ, is your second paragraph intended to replace B? Or is it read in concert with?
What was on this page would replace everything that was in what was printed.
Why do you see some reconciliation with language?
I was just curious why it would replace it. I thought B did a pretty good job of saying exactly the same thing, but maybe not. If I'm
You can do the one.
Oh, wait, never mind. I see it. I'm fine now.
I personally don't need the policy to tell me what I can do with a probationary employee. That's my perspective as a chief. So I don't need it delineated in policy.
And you could add it to your own policy. You can add to the model policy, right?
Good.
That's what, I mean, it seems pointless that we have to even put it in here, but if the law says we have to, then we have to come up with some language that's, I'm still not seeing the 30 days in the reporting requirement. So if anybody can point me to that.
Remember, when the licensee separates from your agency, you have to provide it within 30 days.
It's either 4522 or 4535.
It's 4522.
4522 B.
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 B1D.
No, I'm sorry, I hate to keep, talking about the 45 and the 90. I just think we should pick a number or make it clear that the agency needs to pick a number when they adopt the model policy and not, if they adopt it as written, they can give this person 46 days, they can give this person 89 days. So what, either we pick a number or we just clarify in the policy that.
You're 90.
I'm good with 90.
I thought that's where y'all were.
90. Okay, so we're good with 90.
So the first sentence would say, Iris, applicants hired while the subject of a misconduct investigation with the previously employed law enforcement agency will initially be hired on a provisional basis of a minimum of 90 days. I thought that had consensus.
I'm good.
Victor?
Why are we requiring someone to keep somebody a minimum amount of days? He may decide on day 4 after hiring him that he doesn't want to keep him. And you're saying-
The provisional basis is 90 days, but you could terminate any time during that. It's like,
Yeah, but if you say will initially be hired at minimum, I'm just saying, why are you asking someone to give something to keep somebody on for a minimum?
I don't think it's referring to the retention. It's saying that I have lawfully a provisional period of 90 days, but I can terminate them on day 1.
Well, if you say hired on a provision of a minimum, in other words, you give that person an opportunity to claim, say, I've got a minimum 90 days here.
No,
well, I don't think we need the minimum if you're agreeing on 90 days because we were going to cap it. So you're just saying for a provisional basis for 45 days, right?
90 days.
90 days. I'm sorry.
90.
I would say that a person may be hired for a period not to exceed 90 days. That gives you that window.
So you're saying to strike the minimum. So say will be initially hired on a provisional basis of 90 days. That way it's not,
It's not to exceed 90 days.
But you may need more than 90 days.
and his point is I might only need 1 day. And does this limit, do I have to keep them for the maximum or the minimum? I have to keep them for 90 days.
I don't read it that way. I read it as this is the provisional period. I mean, you can terminate at 5 days.
Yeah.
And you can terminate at 1 year. It's just, we're talking about the duration of the provisional period, which is the 90 days.
It's provisional on day one, and then it goes to whatever number we're looking for.
I think it's inherent in the definition of provisional, but so.
Yeah.
So the recommendation is to strike minimum of and just say, excuse me, be hired on a provisional basis of 90 days. And then we're going to strike Iris the entirety of the last sentence. All right. There is no further.
So are we doing anything with TJ second?
Would be part, this would be A, B, and C. It would replace all of A, B, and C currently.
Yeah, and you're good with C? I wasn't sure if I what you were saying earlier.
Yeah, so from.
You reached the same conclusion that you did, I think, on the other, that they can make that decision on their own. It doesn't need to be specified.
So are we leaving it or striking it? I'm confused.
We're striking
Striking
the
it.
final sentence. You talking about this?
I'm talking about B.
Existing B.
B. Wasn't striking it, no. I was replacing this B with that B.
And you're good with that B?
Are you not?
I'm just.
Who's on A?
That your final answer.
This would become the new ABC. Agreed?
Okay.
All right.
As with the A amended with, as y'all just discussed.
Right.
Got it.
Thank you.
Got it. All right.
So I'm clear, previous, existing 11 becomes what's on this separate page.
Right, with the redaction.
Everything else is gone. Got it.
Okay. I'm gonna request that we do personnel files next so that we can reserve the remainder of the day for the more arduous task.
Do we have a resolution on 7, the psychological exam?
Oh, yes. Go ahead, Rich.
Yes, we do. So 7A would say, before being hired, each, and of course, pending further discussion on 180 days and all that, putting that aside. Before being hired, each applicant must undergo a psychological examination conducted by a psychologist licensed by the Texas Board of Examiners of Psychologists or a psychiatrist licensed by the Texas Medical Board and certified by the American Board of Psychology, Psychiatry and Neurology.
Time, please.
Before
I got
being
you.
hired, each applicant must undergo a psychological examination conducted by a psychologist licensed by the Texas Board of Examiners of Psychologists or a psychiatrist licensed by the Texas Medical Board and certified by the American Board of Psychiatry and Neurology. I can happily email that.
Are you leaving in the designated by this agency language or no?
Y'all talk to me about that because I
Where did that
wasn't
come from?
grasping that.
That's
TJ manufactured it.
No, I think
With
that,
TJ.
Which one?
I do think that is legitimate because that is a problem that we have with some agencies. They allow them to shop and pick their own doctor as opposed to agencies that send them to a particular doctor.
And is that being contemplated by the other committee?
That is something that is being contemplated and discussed, right? So again, but the more conservative approach would be to say that the agency designates the doctor to ensure that that does not occur.
A little off topic, but are there agencies that don't pay for the psychological exam that the applicant or the would have to pay for that themselves?
So what, I didn't hear a recommendation. Do you want designated by this agency in there or not? TJ, you do.
I do, and in part, this looks at larger goals we have where we want to make this process paperless and we want to make it abuse-free. So it contemplates a hiring module that would allow you as an agency to pick a doctor, to send the information to the doctor electronically. They could do the exam, sign the form, and send it back to the agency. That way we're sure there's no loss, there's no tampering, that it's recorded. It solves a lot of problems at once. And in doing that, the agency will designate. So if you don't capture it in the rule, we could capture it in that process later. But if you're looking in the rule to solve some of those problems the same way, you approach those problems by having the agency designate the doctor.
Okay. So after neurology, you would put a comma as designated by this agency. Agreed?
Yes, sir.
Heartburn? No heartburn, comma as designated by this agency.
And further support for that position is 1701-306 and B says an agency hiring a person for whom a license is sought shall select the examining physician and the examining psychologist or psychiatrist.
Wait, TJ didn't know that? Probably did. All right, and we now move to personnel file model policy. Again, we'll do misconduct later because it's going to be more arduous. So I think what Iris passed out was a 2-page document, correct? Is that what you passed out? Yep. All right, so got a lot of feedback on this one. Under section 3, everybody there, by the way, everybody find the document? Under section 3, procedures, this department shall maintain a personnel file on each license holder. The first question the person asked was, is license holder only sworn police or including dispatch from jailers? We know that it's all license holders. So I thought it was actually pretty well stated to begin with. I didn't think there was any ambiguity. Do you all? Okay. Under this person continues, under section 3 procedures, C, the periodic evaluation of the license holder by a supervisor. Comment was, do we want this to be more specific? Like when the first line supervisor evaluates, sometimes that evaluation is overruled by the higher ups. That's weird. I would think that any notation related to a performance evaluation would be included, and it's all, for me, it's all a file. I don't really think there needs to be a change. Under section C1, a letter, memorandum, or document relating to alleged misconduct by the license holder may not be placed in the license holder's personnel file if this agency determines that there is insufficient evidence to sustain the charge of misconduct. So then the question was, well, where then do those investigations go?
Anywhere but the personnel file.
I was like, that's a great question. I hadn't thought about that. So again, under section C1, that person that reviewed this is asking, well, if it doesn't go in their personnel file, where does the agency store it? Well, civil service already has an A file, they have a G file. You're now saying we're going to have a Z file?
No, I think under, what an occupations code meant to be like 143, so set under 1701, it creates that G file.
Yeah.
Or whatever. the
That's what
G
we
file.
started with.
That's right.
Whatever file.
Is civil service city business as usual? Those documents and that type of information goes to the G file.
I think last time we talked about is kind of what were we gonna call it? I think in our conversations, it's basically A and G for 143, but on 143, what do we call it?
Yeah, and that's why this is the model, because that's the standard practice. And they have to go somewhere. So, and they do, but this tells you exactly where they go. So there's no ambiguity out there, which currently there is.
Yeah, I
So
think-
this would make it pretty clear. No, that, I'm just saying that this makes it clear. And that's the benefit of having this model policy.
And then I think that's referenced is what we're talking about here for the non-civil service cities, everyone else. Subsection G, paragraph G, that's section G, I should say, under Roman numeral 3. I think that's addressed there is for non-civil service city, everything that would not be included. Categories under those discrete categories of information under what we call the A file, that's where they would go and how they would be designated in non-civil service cities.
Are we essentially doing an end run on what Austin is trying to do? Because even if they declare that Austin is not technically civil service, it doesn't matter. This new policy would say you're not going to release anything in that non-confidential file. Or that,
I mean, I think their example in Austin is something that we're gonna start seeing in other areas if we don't clear this up. And this is one really easy way to do it, just to make it across the board for all agencies where this information goes and how it's handled. Otherwise, we're gonna be continuously in different political subdivisions, including yours. This is going to become an issue where the outside is trying to question where this information is. And until we clarify it, I guess it's a valid question.
Right. And it goes back to our initial discussions in setting these up. The legislature clearly intended to set up and mimic the setup in civil service cities for non-civil service cities. As a result, you have the enumerated categories under an A, but you also have the result of everything else that goes into purposes of reference, the G file.
I like it. It's clean. I like it a lot.
Yeah.
I like it because of my politics.
Does this capture, you talk about cities, I mean, civil service, 143, and then cities that don't have civil service at all. What about like cities like mine that are 147? Different. So would this supersede anything that my city in Dallas does? And it would dictate what the city of Dallas will do?
Depends what they're contracting for. Give us an example how that would affect this. Give us something that would be different.
I don't know. That's the unknown that I can't describe right now because I'm
I
not.
think I would argue that it would, that G would. It would impact the way Dallas, for example, because they're charter civil service. Now they are able to assert an argument under G, which will become law once this is adopted, will become rule.
Rule.
So mandated by state law. Mandated by state law that you shall adopt the rule. That they can assert this legal argument that the G file, that information. So background investigations, unsustained complaints would now be designated as confidential for statewide employment database under Texas Occupations Code 1701-168. That would be a legal argument they could assert until, you know, as we've argued before, we could codify this in the legislature. But it would be an argument that we could assert, and that's what we talked about. That's what we talked about in the subcommittee.
That's right. And I think if you take a step back, the state legislature is compelling chief administrators to create alleged misconduct investigations where there does not exist that duty now. As a result of that, you're going to have investigations that are unfounded, and you're going to have information that does not fit into the A file categories. Those unsustained allegations, which weren't required to be made, or allegations and those investigations weren't required to be made now for non-civil service cities. Now you're requiring it. So we're making an argument based on reason here, that it only stands to reason if you don't have information. You can't put it in the A file because it's unsustained. It has to go somewhere. As a result, each individual license holder has a reputational right. The courts have recognized that reputational right, that the public does not have an opportunity to look at that information. That's what we're basing non-civil service cities confidentiality on. And plus, it's designated as its final destination in the TCO essentially the statewide hiring database. That's what it is. So that's how.
Confidential database. Those
Correct.
specifically said those things are confidential
Correct.
in their handling.
That's correct.
So then it's not susceptible to open records requests.
Oh, people can request it, absolutely. I think
Not
that.
the release.
That's, and I think that's why we're putting it in the model policy, is the argument is going to have to be made that this is designated for all the reasons that we just talked about. This is designated for the statewide confidential database. As a result, it can't be released to the public. That's going to have to be the argument that's made, because as we've discussed before, in all candor, the 4522 and 4535 does not make this information expressly confidential. However, based on the similar, exact same, I say similar, almost identical provisions under civil service, I think there is a very clear intent that this information is to be confidential. It has to be confidential because it does not fit in the public file. And again, going back to those reputational rights that have been repeatedly recognized, it has to be protected. And again, that prong of it, and also it's designated, its final destination is a confidential database for statewide purposes.
The one issue I think G fails to contemplate is Brady is constitutional law. And Brady says that you shall disclose G file material to your district attorney upon request or upon knowledge of any exculpatory. This doesn't contemplate that.
I think with respect to Brady requirements, constitutional requirements, the provision in 1445, if I'm almost certain, is as required by law, whether it be for employment purposes or obviously Brady purposes. If there's a subpoena in federal court, obviously all of those, I'm talking about in the context at the department level for public release.
This is for DIR.
Correct.
Open records, yeah.
Correct.
A couple other things to talk about, but the feedback I got back from Dallas PD with regard to section G was to add the words external on the last line. So that would be to any external agency or external person. I don't know if that's worth spelling out, but that was the only change that I got back from Dallas PD with regard to
Julio
the,
sent you.
yeah, he talked to his legal people apparently.
So an internal person could have another person's G file?
Their argument was that it's imperative that the CAO, whoever that is, have access to the file for use in lawsuits, disciplinary proceedings. I'm concerned that the confidentiality provisions will create confusion with other legal processes, such as discovery or subpoenas.
City Attorney's Office.
Okay, and therefore we need to make sure we have some carve-outs. That's what Dallas indicated. I don't know that that's necessary,
Nah,
but
it's not.
because in light of the conversation, I wanted to make sure that I shared it with the group.
And-
For G file stuff too, city attorney gets, that's a G file. It works fine.
Yeah, I would think it's already,
That's the language from G currently.
yes, I think he's.
You know, I have to represent the people.
Well, I know
that
I know our city and department.
These are your people, James.
Yeah, yeah. Not my people. But I know what they're going for. They get in the weeds like we do, but that's just taking it beyond what I think. I think it's covered pretty well, pretty clear.
Okay.
But I know Julio had to send that in from
And
our
again, I think
department
for
standpoint.
purposes of the statewide confidential database and hiring purposes, obviously, this is not going to contemplate every instance. We can't put under federal subpoena, under Brady requests, things of that nature. Obviously, those things are going to have to be reviewed because as the statute says, as required by law, we're talking about for the purposes when this information is at the agency for Public Information Act requests and for when it comes to TCOL for the statewide hiring database.
Noted.
Just for my own personal clarification, if this is a model policy for everyone, but the agency could adopt it, adding some clarifying and text in there to adapt to their agency, right?
Yes, sure.
As long as it doesn't substantially change.
Obviously, they can't make confidential information that's not otherwise, things of that nature, but that's a great point.
But like she means they could put, but the city attorney can look at it.
Yeah.
That's right.
And I don't think that that's going, that happens, that's okay. I mean, it just, needs to stay in the house as best it can. I understand the city attorney who's on our side needs to look at something, won't be objectionable to that per se. My biggest thing is, and I think from our standpoint is, we just don't want it out for the general public.
Right.
I have one request then on G, we remove the word model. Because a lot of people will literally copy and paste this. So it's about the fourth sentence in subsections A through C of this policy. Get rid of model.
Can I also suggest that we change police departments to law enforcement agencies?
Thank you.
To see if there was a reason why I was police and
G.
G, sorry.
LE agencies shall maintain, okay, good catch. Okay,
Chief, if I can, while we got it here, I know it's referenced once in subsection G, and this is a change from Gretchen. And this is the conforming change, just like we'll do Texas occupations code throughout on this. We'll also reference paragraphs instead of subsections on this to make it conform. If you want to give us the latitude to do that as we go through it.
Chief, maybe it's just a formatting error, but it has C and then under C is 1. But I don't think, I'm sorry, on page 1. But 1 and 2 should not be under C. They should be standalone.
oh, yeah. Says the subcommittee.
Yeah, that was something that my folks indicated also, that the formatting is a little bit odd right there. Section were numbered differently.
That 1 and 2 applies to everything, and in reading 1714535, 1B is the periodic evaluation, and then it starts with 2A, a letter or memorandum or document, so that should be pulled out from under C.
Okay.
So I think we could resolve it by just making 1D 2E and then changing the numbering down. Unless anyone's,
One would be a continuation of the current C, correct?
no.
Provide that.
No, because C is a discrete category that falls under the A file.
So, and if you want to confirm, go to 171.4535.
Yep.
And this is basically a copy and paste of that. And 2A starts a letter or memorandum in 4535. That should be.
Okay. So for Iris's benefit, really Iris is for Stan's benefit. Tell us exactly what you're suggesting on the numbering again. 1 becomes D.
Correct. 2 becomes E.
Becomes E.
And then we continue down.
And then little letter A becomes what? 1.
Unless we want to break now 3 procedures down a little bit further, which we could. But that's a good start.
Okay, can we read the existing C then? Because it really can't stand alone unless it's modified.
Agreed.
Okay, so strike provide that.
And I think in provide that refers to the procedural letters and everything else under current 2 little a and little b. Would that be right? Right.
It does in the bill, yes.
And then, so this is kind of just formatting stuff, right?
Making it match the law.
Yeah.
It got misaligned.
And I may say that as we were finding out going through the chart, it's a little bit disjointed because current, not as amended, C1, a letter memorandum, you have C. That belongs in the A file. And then we have the next as written that may not be placed in the personnel file. But then we have if a negative letter is included in the personnel file. So we have a little bit of
The numbering.
it's an organizational thing is what I'm talking about here is maybe we have removed that here's what belongs in the personnel file. And right now, it's like, this doesn't go in the personnel file. Oh, but here's some procedural references to what goes in the personnel file. Maybe a reorganization of it may help. I know how it is in the statute, but we have the opportunity now to maybe make it a little smooth. Thanks.
Fully support. So staff is going to do that?
We can do that.
And just along those lines, note on subsection D, it says, except as provided by subsections B and E, both don't.
Yeah, they'll have.
Gotcha.
I made note of that too.
We'll make conforming paragraph references. If y'all, once you get through the substance of this, we can, I don't think it will be major type surgery to do it, but I think it's just a matter of just reorganizing some of these paragraphs.
So another minor substantive change then to consider in F. It says, as provided by that section, a law enforcement agency hiring a license holder. The requested change was a law enforcement agency investigating an applicant for employment is entitled to view. Because we may not actually be hiring a license holder based on what we find. I think just the thought process.
So that broadens the categories of people who, officers who can view the file. You can only view your own file, but it broadens the categories of people who can view their own file. Would that be right?
She's just making the point that you don't hire everybody to do a background on, but we can look at the file everyone in background, right? But you might want to include providing the signed release of information. That has become an issue where agencies are requesting it, but they don't have a signed release. And so there is the question of whether or not they're actually doing a background or whether they're just trying to look at somebody's file.
And that is in the hiring model policy.
Yes.
Could you just put the word considering in front of hiring?
What is the intent of F? Is the intent that one can review their own file?
So note on that. F and H, as they're written right now, are essentially the same thing. They don't contemplate explicitly what's in 1701 now for the agency can review it for purposes of 1701-303, 1701-451, or the license holder viewing their own file. So I have some suggested language. It would essentially strike the existing F since H is basically the same thing. So it would go E, the agency shall provide a license holder personal file. F, law enforcement agency shall maintain a file on a license holder, et cetera. And then new G would be what was H as provided by 1701-451, except, and I'm gonna, sorry for the confusion, what I would propose new G with the reorganization would say, a law enforcement agency hiring a license holder and taking into account what we've talked about, investigating, hiring, whatever we come up with, a license holder is entitled to view the contents of the license holder's file maintained under paragraph, what would now be F of this policy for purposes of section 1701-303, which is the initial licensure process, 1701-451, which is the hiring process. And then a license holder is entitled to view the license holder's own personnel file, because I know that's been something that's come up when we've been looking at this whole bill, is making sure that they've got the opportunity to see their own. So it would capture all of those situations in which somebody could view this file that are under 1701 now.
Just can't take anything with them or Xerox or copy, et cetera.
Well,
Okay.
I thought that was up there on 4. A license holder is entitled on request to a copy of any letter, memorandum, or document placed in the license holder personnel file.
Are you requiring hiring in order to view a file?
We're talking about 2 different things at the same time. But as far as the license holder themselves, they're entitled to a copy of anything in there, right?
Under the view file, no.
They can view it, can they not?
They can view it. They're not
Entitled to
entitled to a
view.
copy of it.
Internally, right? So, yeah.
You say otherwise? It's just historically been the practice for civil service agencies that you can look at your G. You just cannot Xerox and or keep copies of the G.
I'm just looking at number 4 at the top of page 2.
It would specify that here's the A file, I'll use personal. Because this is personnel.
That number 4 is applicable to their A. So number 4 is all A file.
Right.
And they're allowed to have anything in A file. That's correct.
They are entitled to a copy of that.
Yes.
That's a file.
We don't even really get to G files until big letter G.
But the G file and in the new law, is it written, it's mirrored the G, so I think that'd be right probably.
Right. I have a crazy question on current letter D, big D. Except as provided by sections which don't exist. This agency may not release any information contained in a license holder's personnel file to any other agency or person requesting information unless required by law. Public information access, every bit of the A file is public. Or why are we saying that you can't release it? The PIA says A file is fully public. Anybody can request it. I'm a little lost on why the subcommittee enumerated D.
Is it referring to individual pieces of information in the A file that might be redacted before release?
I think so.
Well, so I can request Jessica's performance evaluations for all of her history
Sure,
right now, and I should be able to get them because they're all A files.
correct, but there may be individual pieces of information, identifying information that would be redacted before release. I don't know if that's what it's referring to, but
I think so, yeah, because then it will,
Has to do that anyway, for that.
Right.
They have to codify here.
So what is D telling me?
I think it's,
It's
I
just,
think it's the last sentence that what it's supposed to be telling you. The top part doesn't make any sense.
well, I think more than anything, it's, I'm maybe saying that you can't, someone in the agency can't release that on their own. It's prohibiting just one employee from releasing someone else's information unless it's required by law. In other words, just an ad hoc release. Someone calls up and says, hey, can I have so-and-so's telephone number? You can't go to this file and get it. It has to be done only through a Public Information Act request or something like that. And then redactions have to be made as appropriate. And only information that's public can be released.
I can see that, yeah.
It's a prohibition against ad hoc releases.
Yeah.
Okay.
In that, in dovetailing onto that, as it is right now, 143.089 has the provision, subsection F, director may not release information in personnel file without first obtaining the officer's written permission, comma, unless release is required by law. So that's, I think that's being echoed here is that as it exists right now.
okay.
So I refer to a department.
I'm sorry, Chief, what was that?
So why the provision to refer whomever is requesting information that otherwise you would not release unless required by law? Why have a provision here referring that requester to the agency head? It implies it refers to him or her.
And I'll also refer to 1701-4535. This is where this language is coming from. This may answer your question, Chief. Except under subsections D and E, which I think that's what we're referring to here. This is under new 1701-4535 subsection C. Again, I'll start at the beginning of it, except under subsections D and E, which is referring to send it to TCOL and in the 451 release with the written consent Agency may not release personnel file information to any other agency or person unless required by law. So this is coming straight from U 4535, which mirrors the subsection F under 089. And I think that's what this is doing, is just copying that same information.
Yeah, it was a cut and paste job.
Yeah, an agency shall refer the requester to the agency head or designee. That's in 4535.
And in practice, that's how we do it currently. If a PIO request comes in, it goes to the chief and or the records or legal services.
In that paragraphs D and E that this is referring to, that's mirrors what's in the statute. And like you said, this was a copy and paste from the statute.
So formatting, this needs quite a few changes, which staff is going to do. I think everybody is very supportive of big letter G and how it's written and the intent behind big letter G. I think, by the way, this could be a selling point for respective chiefs and sheriffs and chief constables. I had a request when they reviewed this on section 3 procedures under B. It says any misconduct by the license holder if blah, blah, blah. They said, could you replace misconduct with any sustained allegations of misconduct?
You could, but that's not what the statute says.
Got it. Perfect. That's what it needed.
Okay, we
I think
can.
That's going back to our original sustained and unsustained, everything gets documented.
You can't have it sustained.
All right. Any other questions or concerns on this one? I was looking through my hair, final one. The question was asked by a person who reviewed this policy. He said, if I'm understanding this correctly, we wouldn't regularly update a TCOL shared file on each employee, but would only need to provide the shared file when they separate. We've talked about that. I would like clarification on this point to make sure I understand it. I thought it was pretty clear. Have to 30 days after separation. If it's discretionary, if you want to do it as you go. Agreed? Okay. I have no other. Did you give both of Dallas's? Okay. I have honored everybody's inputs. Oh, nope. Got Kilgore over here. Kilgore says on E1, what is E1? Not later than the 30th day, okay. He says, does that mean we keep a copy at the department and send the original file to TCOL when someone leaves? I just wasn't sure how that works if we have to maintain the files for a certain period of time for records retention purposes. We keep the original and send a copy. Okay. And then he says, oh, this is different. And then the other one, and I failed to catch because I got all this paperwork for me. The chief asked, on this hiring procedures model policy, I noticed y'all did away with the 180-day break. I mean, Susan, sitting near you. All right, anything else, Jessica?
I don't. Christie, did your stuff? That was that discussed?
Printed, Christie.
Yes, I think he just covered it. It was the sustained allegations inclusion.
Okay.
The one that TJ so abruptly shot me down on?
Yeah.
You want to say that to her now?
I'll relate to my
I think the confusion there potentially comes from the definition of misconduct in the bill, which is probably going to be brought up in a little while.
Continuing conversation. Think I'm good.
Good. I think I'm good. You had some grammatical recommendations. I'm just gonna give these to Iris versus me going through shalls and shall nots. I'm just gonna give these to Iris. And then staff, when you do the formatting changes, y'all can look at Christie's suggestions versus TJ shooting us down again. All right. Thoughts, questions, or concerns on personnel files model policy?
I just wanted clarification on what you were talking about, John, with the except as provided by whatever statute you referenced about the department not releasing any information containing the department to any other agency relating to the license holder. That language in subsection D or section D in paragraph G, the same, it looks, this reads the same. The last sentence of what is now G. Do we need to still have both provisions in there?
And in the agency shall refer the person, that language.
Yeah, well, this is the statement before it. It looks like in section D, paragraph B and paragraph G, there's it's the same, except as provided, the department may not release any information. I guess the question is, does it need to be there twice?
Are D and G referring to different documents?
Yes. D is the A,
Correct.
G is the G.
Okay.
So that's why it's in two places.
Let me look
That's
at
what
the
confused me earlier.
the sure here.
I just wanted to make sure I understood it. Thank you.
No, that's correct. That's D is still referring to that A file. And as it exists now, prior to relettering, I should say, capital G refers to the G file, civil service boards.
When you all format, I agree that this is a pretty significant change for non-civil service agencies. And they should recognize the gift they've just been given. But they need to clearly understand, we just created a separate file for them, and here's the reason why. Right.
Which they most likely had anyway, but it also makes it confidential, or at least gives them the ability to assert
Ability
that
to
argument.
raise confidentiality. And again, I want to be crystal clear on that. Unfortunately, the statute does not expressly say this information is confidential like it does the G file. However, it's clearly designated to be confidential and it should be produced in a way that it's going to be kept confidential. And I think in conjunction with all of this, and this is certainly coming from staff side, we want to help, I think, educate and set out at least some technical assistance bulletin or something to allow them to raise the exception at the agency level for non-civil service cities who get requests for G file or G file similar information. That way they can at least attempt to, I think there's a lot of really good arguments that can be made in absence of that express provision that we're talking about, that at least will allow us to build a bridge until it can maybe be more specifically addressed early 2025.
There'll have to be a lot of training going into it out to the smaller agencies and some of the counties I think a lot of them may not realize how to set up that system of an A file and a G file and what goes in one and not in the other.
Jessica and I are going to do a class for TPCA's upcoming. Because she loves teaching it.
Well, and I think a lot of smaller town HR departments, because they want everything that you've done, whether it was sustained or not, and they'll have to understand that here's the system now, and you can't have that. It is a difference.
For formatted considerations. And I don't know how you want to do this, but just throwing it out there. We talk a lot about A files and G files, and right now this is handy as big G.
Correct.
I don't know if we want to keep the Gs.
We're going to see the best way we can possibly line that up, because I thought that was great the way it was. But we've got some, we'll figure it out.
There are options.
Yeah.
Just as long as you're.
No, absolutely. Yeah.
And that will help us in future conversations to have to only refer to
You bet.
Gs generally.
I think that's good.
We will need all of your help because another big sea change in all of this, not just for agencies that aren't civil service having to reorient their files, but the fact that all of this is gonna have to be sent to TCOL. We need as much help spreading that word as we can get.
And going back to that organizational point earlier, the way I see it right now, obviously this is just right here in the moment, is we would like to set it up as close it is to the civil A file with these provisions and what belongs in there, and have a subsection G here. So we're not
Yes.
is making it as clear as we possibly can through organization.
You guys are on it.
And it would be awesome in the model policy if the G remained the G.
That's what we're shooting to do.
Keep the Roman.
What?
You want to keep the Roman numerals.
Well-
I think you guys can patch that out in terms of structure and.
We'll get there.
Okay, it is 12:05. I think we have fully hashed personnel files with more work to be done by staff. As soon as they communicate those changes, I'll get it to the remainder of the committee. We're probably gonna need the majority of time, so let's take about 20, 25 minutes to eat on-site courtesy of TMPA, and let's come back together and knock out misconduct, not knock out each other. Captain, are you good on your end? We're gonna take about a 20, 25-minute break.
Yes, sir. How does TJ from TMPA get me my sandwich from Jason's Ear?
Put it in the mail.
Okay, I'll look forward to it. All right, 25 minutes, Chief.
25 minutes, yes, sir, 25.
Thank you.
All right, I have 12:40, so I would like to get us started again. No, James was on the phone call. TJ presumably will be back. Captain Rice, the sandwiches were way better than Amarillo weather, sir.
Okay.
Weather's not terrible here today.
Sorry. All right, so we are going to now move forward with the misconduct allegations model policy. And have comments. So we'll just start page 1 as we have been doing. The comment was, the purpose of this policy is to establish guidelines for investigating allegations of misconduct. That's intro. General comment on the word policy. If it isn't passed by city council, it isn't policy in Dallas. This has important, so maybe you did submit this.
I guess I did.
This has important ramifications for civil rights claims. Accordingly, we need to make sure Dallas can just use the term procedure on all of it. James is not here to defend his agency.
Is the claim that the document that governs Dallas police officers is either adopted by a council and called policy, or it's a procedure written by the chief?
Now,
I'm not sure that it matters. I mean, this is a model policy to help guide and shape other people's policies. So it can be called whatever it wants to be called. Dallas will call it whatever they want when they adopt it, right? This feels like a nothing burger to me.
What?
Not a big deal.
You said something different.
So nothing burger.
All right.
distinction without a difference.
Number 2 comment. I think we need a reference to the fact that other applicable laws must still be complied with. For example, 614 of the Texas Government Code.
I had brought that up briefly as well. The 614, I just thought there was language in there. I'd have to go back to our conversation, but there is some language in there that I don't think it's much different from what we already have, though. At least I didn't see anything. It might be a little more robust than what we have. I'll try to pull up my email to get the exact.
While you're doing that, section 2, definitions, misconduct. Do you want to distinguish between intent and reckless disregard versus mistakes? I don't think the statute differentiates. That's where we had the issue. Agreed?
No.
So I'm probably a fourth sentence. For purposes of this policy, allegations of untruthfulness shall include false, untrue, or misleading statements, either by overt means or by omission. They said they recommended for purposes of this policy only. Misconduct does not include minor rules violations of a less serious nature. Then they added, however, I assume they added, I don't know if this is in the original. Nothing precludes the department from investigating conduct not classified as misconduct in a similar manner. Is it that she ended up?
Chief, I think to that point, nothing prevents the department from going much deeper into however far they want to go. Absolutely.
I don't know that I need to be told that, but Dallas likes it. What says you all? Do you want to add a sentence at the end of the misconduct that says nothing precludes the department from investigating conduct not classified as misconduct in a similar manner?
Well, again, so that goes into the problem with it is that this isn't just when you investigate, unfortunately. I wish that the policy was just when you investigate. What it also does is talks about those investigations being reported to TCOL and going into a database that we don't know much about right now, what that's going to look like. So again, I think in that context, I understand their argument there, or I guess it's concerning that we would add that statement there to me. If it means that you're now going to also include all those, whatever ideas this person has.
Yeah, because if you do the investigation, it's got to be uploaded.
It's going anyway.
I see your point.
I think you could do an investigation into something that didn't meet this criteria and then not submit it to TCOL. But. Sorry, but
That's a can of worms. When they first started to do an investigation, I thought it was reasonable to did it. And you gotta remember that the point of all this is to give somebody leaving this agency going to another one to give them that idea of who they're hiring. And so I think if you did that, you'd open that.
Gonna be there anyway.
Kind of work.
Yeah, I don't think this precludes them from conducting an investigation for their.
That's my point. That's
Even as is right now.
Correct. Without having to specify.
Nothing precludes it even if we don't strictly say so.
Right.
Exactly.
All right, so we still need to rectify their recommendation on the sentence that starts. In our policy, it says, for purposes of this policy, allegations of untruthfulness shall contemplate false, untrue, or misleading statements, either by overt means or by omission. Dallas is asking, would you change this statement to say, purposes of this policy, allegations of untruthfulness shall include false, untrue, or misleading statements? Really, all they're doing is just using different language, but they're saying the exact same thing. I don't see any need to change, but what says you? They didn't like the word contemplate. They want to use include. Y'all want to use include or contemplate?
I'm good with include.
Include is a pretty simple, straightforward term versus contemplate. We can contemplate a lot, and we have over cookies. What do y'all want? What word do you want? Jessica? You want to include?
I don't care about that particular.
Complete TMPA?
I mean, I don't think it matters.
I think include is more clear, but
Let's use include instead of the word contemplate. Dallas goes on to say, under summary report, a report providing our second bullet says a synopsis of each statement. They want a synopsis or reproduction of each statement.
can I ask for some clarification? Are we talking about witnesses you might interview during an investigation? This is their statements that were included in the summary report? What statements are we talking about?
So I know that in an internal affairs investigation, very often, instead of doing a synopsis, you will simply embed their statement in your investigative summary. So I think that's what they're asking. Instead of having to do a synopsis, can we not just reproduce what they said in the investigative narrative? That's the way I did it when I did IAs. So I would
I
actually.
just don't think that's part of a summary report.
Right.
I'm not sure we need to go into that level of detail in the summary report. In fact, I think we just strike that whole bullet point. For me, and sorry to broaden this a little bit, I want, what is the allegation, maybe some quick information about what the findings were, and then the disposition. I don't, if I need more details, I go to the actual report. Less is more for me on the number.
I don't even call this a summary report. I call this the actual suspension document, but that's beside the point. All right, so Dallas wants it to include oral reproduction. TJ wants to strike it completely. What does the committee want? Not all at once.
Strike it completely.
Let's go.
I don't disagree with TJ's logic.
That was very non-committal.
But
What is the purpose of the summary report?
I don't know. I don't do
I think the summary report is, I see it two ways. One is a tool for the next agency during hiring. And it's also some proof to TCOL that an investigation occurred and this was the final disposition. Anything above and beyond that, you go to the actual file for the details.
And the legislative intent of the summary report is basically what's replacing the F5. So since we don't have a checkbox with a category, we now have a summary report, which gives them just a brief synopsis that they can either investigate further because they're still interested, or they can go to the next applicant.
What I don't want is a lot of extra work after an IA is concluded. And now I have to take a written statement from a witness or from the subject of the investigation. And now I have to boil it down to a couple of lines to put on another form. And I don't want that.
Yeah, that's true. If you have a tremendous number of people interviewed, that could get quite cumbersome.
Oh, yeah. And this goes again to the, an IA file from here to the floor that doesn't have to be uploaded, that doesn't have to be in a storage system, that can be, this is just flagging and showing. That's the whole purpose of the statewide employment database. Okay, there was an incident. Here's a report. Okay, let me go find out more about it. Certainly.
So TJ, would you strike all those bullet points or just 2, 3, 4?
Hang on, I do want to make sure that we're not missing something.
That's what she's asking. So hang on. Go ahead, TJ.
And that's that, TJ.
But he said, hang on, so.
My question was what the purpose of the summary report was, and I want to make sure that we're remembering there's two different purposes for it. We talked about this exhaustive officer-involved shooting, huge investigation. We got to summarize that. You can look at it. You can tell from that he was no billed, he was cleared. I'm comfortable in hiring him. But the bigger problem that I think the legislature was trying to address, and again, we're trying to replace the F5. I think John brought up that point is that we have a lot of agencies who did not investigate, who did nothing, or who will write a short thing saying he quit, I couldn't talk to him, the complainant wouldn't come in and give a sworn statement, investigation complete. And you won't be able to tell that if you don't at least make some effort to reflect whether or not these things occurred. If the purpose of that is ensuring that the investigation was done and you can make an informed decision, we need to capture that in some means. I think most investigations have some summary that at least talks about who was talked to and what information they provided in some sense. I don't think you want to completely exclude. If none of the witnesses were investigated, or none of the witnesses were interviewed, how good is the investigation?
So not showing off shooting is misconduct?
No, I'm sorry. It could be, right? It's the use of deadly force. It could be investigated, right?
Can you look in Secure Share? Do you have access as enforcement to Secure Share?
That's a portal between two agencies. We just.
So there's no way to make that happen where enforcement can look in Secure Share
What?
for an investigation, for the actual investigation.
That was my question, is what is the purpose of the summary report? And if part of that is for TCO to make sure that an investigation occurred, then that should be from the summary report, not going and looking at the actual investigation. Right?
I mean, the legislative intent, as far as I know, was for the F5 replacement summary report of how the separation occurred. And then, if there is some other intent that enforcement is going to come down on chiefs and sheriffs, then I think if they can get that information through Secure Share, which is already up and running, if they have a belief that nothing was done, could they go in and just look at the prospective employment file to see if that was done? That was something I was wondering, contemplating this.
I see your point. I'm just not sure how much we can get into the details of how the investigation is conducted. I just, for the summary report, I see there's an allegation of misconduct. There's a few minor details there on the form, and then here's the final disposition. To have the form kind of walk you through, you did this in the investigation, you did that, I think gets a little bit much.
Yeah, and might exceed the scope of what we're really trying to do here, because we don't want to produce a form that somebody's then going to say, well, you did this investigation wrong. Well, that's not at all what we're trying to accomplish. It's just a mechanism.
Memorialize that an investigation was done.
And so, again, I guess my question, are you comfortable then with, or is it, would you strike the 2, 3, and 4 bullet?
2 and 3 for sure.
I agree.
I agree. 4, there needs to be some field or some box to kind of explain what the allegation was in a brief description of something that occurred. I don't know what we call that or how big of a box we give them but there needs to be, this was the allegation. This was what we did about it, maybe. And then the final disposition.
Okay, those the 3 things. Does any other relevant information? I don't know what that means. I read that policy and I'm like, I don't even know what that means. It could, everything is relevant in this line of work. I would be okay with striking the 2nd, 3rd, and 4th bullet. Simpler is better.
I agree, because it allows for discretion too.
All right, so is there consensus to strike? Staff is still quizzical.
So my thinking is, and I don't want to belabor this point too much, but Jessica, when all of this was coming up, Houston PD was talking about basically, what is it, a 3x5 they all call it, versus full investigative report. Does that 3x5 as described kind of meet what we're contemplating putting in here, striking 2, 3, and 4, and just having the rest? Is that kind of how you're seeing it?
Yeah, I mean, before striking it, that would be the summary report that we do already.
Okay.
But yeah, the 3x5 does capture that stuff as well.
We're also not trying to have agencies duplicate a ton of effort where you've done this whole thing and now you've got to create this other summary.
Because I got a lot of questions about that, how much work this form was going to require. And I said, my view is it's 1 to 2 minutes of work after you've already done a lot of investigation and it's done. And now I just fill out this one form or however it is, and then I'm done. I move on.
All right, looking for consensus. Gretchen? No?
I have a few thoughts and I don't, I could be mixing this up with a different advisory committee, but I do remember about wanting to have some kind of guidance on what the report should be, because so that there is some form of consistency across agencies on what they're delivering, or at least guidance on what the report should consist of. And I'm wondering if that's how those items, bullet point 2, 3, and 4 ended up in there. The other thought that I have is the summary report should probably also indicate whether or not this resulted in separation.
Yes, I agree.
I missed it, sorry.
Do we have a model report to go along with the model policy?
I will say, I envision TCOL creating a form that the agencies, I know we discussed this last time and we kind of said no, but I envision a 1-page form that TCOL creates. The other thing is if y'all are receiving all different formats of forms, that's going to be difficult for y'all to manage. And maybe even one day it's electronic and you just enter the variables online and submit it.
We can certainly create one and circulate one in response to that.
Maybe that's where we handle like the guidance is in the instructions on the form is like this section can include things like.
I think honestly imperative. We have something online that smaller agencies at least, if they have this, they're kind of wade through this, that they can go to the office website. Okay, this is what I need to do, this is what I need to upload, and then they. So the larger agencies have their own process, they can do that too. But if we expect the smaller agencies, the less than 50, offer to comply with it, we're gonna have to make it easy.
So far, if I understand the consensus, you don't want any type of narrative in whatever that form is. It's more objective. It's well, you've got a description of the allegation, but it's more couched into use of force or, whatever, absent without leave, whatever that is, as opposed to a descriptive narrative. And then it was sustained, it was unfounded. Is that what I'm kind of reading?
I think it could include a very small.
A brief narrative.
Correct. I'm okay with that, but if we agree no, I just don't want it to be too long. And
I'm okay with both narrative and checkboxes.
You could have check boxes, obviously, that mirror your misconduct definition.
Yes, that's right.
That's-
Yeah.
Which of these applies? Maybe a description of the allegation, maybe a brief description of the findings, and then the checkboxes of exonerated motion.
This is great. This is helping me build that.
And Chief, on the last bullet point, so my agency uses 4 categories for IAs. We call them unfounded, exonerated, inconclusive, and sustained. And we have exonerated, unsubstantiated. Would y'all be okay with using those 4 categories, or do other departments use something
I
different?
was commenting on this and had some of the exact same concerns. Find it. You had it up?
Yeah. They don't have unfounded, and they say this bullet seems to mix the investigative findings and the discipline.
Yes.
I would avoid enumerating unless we are just giving examples to have more flexibility.
I agree. They should be separate bullet points. Here,
We have to have both.
Yeah.
By law.
correct.
Affirmative findings or not, and then what was the action, what was the discipline administered?
Bennett, yes. Mhm.
If sustained, then you have this.
Yes.
I was wrong. It was not to disclose who it is, but it's Ganaway. So, Julia said. Hang on, I'm pulling it up. Our thing would work. She had some of the same concerns. So we are intentionally not using the normal sustained, not sustained. She's more comfortable using, because it's either sustained or it's not, versus you use 4 different categories. SMPD uses 4. Keep it simple, sustained, not sustained. I didn't agree with her.
Yeah,
I did agree with Julia a lot.
if it's not sustained, then it's
I agree.
the other, yeah.
So the recommendation, and this is the final bullet point on summary report. And the final dispositions of each allegation, including sustained or not sustained, comma. That actually goes into the bullet right before that. The investigative findings is what is sustained or not sustained. And then the disposition is what you do with it. Did you reprimand or did you suspend?
So why don't we just say the final dispositions of each allegation? Period.
Yeah. Leave it. So the investigative findings of each allegation of misconduct, sustained or not,
Sustained or not sustained.
and then.
To include sustained or not sustained, ours, sustained or not sustained. So we're on the 4th, 5th bullet point, the investigative findings as to each allegation of misconduct, comma, to include sustained or not sustained. Then the final one says, and the final dispositions of each allegation, including No action, written reprimand, temporary suspension, demotion, or indefinite suspension.
Well, his point was just put a period after.
Then allegations, but
Final dispositions.
And the final disposition of allegation?
Yeah.
Okay.
Because then,
and let the agent put whatever.
yeah, then the agency can put whatever they've got, or if they got 6 or 4, or how many of them.
So everybody understands what a disposition is? Because we had a lot of argument over this. I'm supportive, I get it. But I'm trying to interpret this for a West Texas chief who's been a chief for 2 weeks. Does he know what a disposition is?
And for what I hope is one day an electronic submission where you're just selecting it on the TCO website and not typing in your own wording.
Drop
Say
down.
disciplinary action instead of disposition? If applicable?
The problem is you redefine discipline in a civil service world because a written reprimand is not discipline. You can't merge those two in my world.
Okay.
Why are you all opposed to giving examples of final dispositions? Let me ask it that way.
Does it have to be in the model policy or can it be handled through?
It can be handled through the form submission. But if I'm trying to think, these policies should be somewhat instructive as well. And so if I'm a brand new chief, go through a new chief development course and I have to land my first investigation, I may not know what a disposition is. So if you already have the form up, then I can figure that part out. But if y'all haven't even agreed to do the form.
We will be doing.
Oh, Jessica says they'll do the form.
I think the only hang up is
Okay.
agencies just have so many different categories that are different from one
Right.
another.
But your form has to contemplate no action, written reprimand, temporary suspension, demotion, indefinite suspension, which is AKA termination. Has to have all that language.
And I mean, if there's no separation, then the form doesn't have to go at that time. So that's what also kind of muddies the water here.
Okay, so that you just made me think of what would we also want resigned in lieu of termination? What's this
I
label?
mean, but it shouldn't impact the investigation now that we have
So-
this.
That's a great point, because the whole idea here,
Yeah.
of course, is that they resign before the completion of the investigation. So it's not even in lieu of termination, because you might not have, maybe you weren't going to terminate him. And they just said, I'm cutting my losses here because I don't know how this is going to turn out. And they resign.
Resign.
They resigned while under investigation. And so maybe, but now you have to complete the investigation.
Yep.
And you have sustained it, but there is no action taken on a sustained. They don't work there anymore. They hadn't worked there now for 2-3 weeks. So there needs to be a category for, that's actually no action, but I think there needs to be, and this is kind of what you guys are looking at, is how do you reflect that, well, I mean, I would have suspended or I would have terminated, but it's really no action. So how do we reflect that? Or do we put no action?
I say we don't, but we have to per the statute, right?
Yeah.
Because I think it would make sense not to, because it doesn't, if you're only doing this really upon separation, unless you choose otherwise.
And perhaps you have something that says resigned prior to completion.
I just put resigned during investigation. That could be any point. This is my lived experience. I lost a SOA hearing because they argued the officer did not realize he was going to ultimately be terminated. He resigned because he wanted to resign. I lost that appeal. Because you can't prove at prima facie that he knew he was going to be terminated. Although he knew the nature of the allegation, he knew Stan's values, he knew he was going to be terminated. I still lost. So I like that.
So what's that verbiage? Resigned.
Well, we're going to just leave it and the final dispositions of each allegation, period, on the model policy. Then your all's form will have no action, written reprimand, temporary suspension, demotion, indefinite suspension, termination, resign during investigation. That's pretty comprehensive. I've not done any other thing outside of that.
Yeah, what else? What else is there?
Criminal charges?
Oh.
Criminal charge filed, yeah.
Oh, here's the deviant mind there.
Well, that's not a personnel action.
Correct.
So I think that's
That's a good point, because even if you refer to criminal, you're still gonna do something internally.
And you still got to report on
Yeah.
criminal charges under the.
I'd say you keep those.
The form could ask the question, are criminal charges also being filed, yes or no, or something like that.
That's right.
Keep it.
Yes, no, and pending.
Sure.
Yeah.
So just so I'm
You good,
clear,
Jessica?
Yeah, yeah.
so I'm clear, chief, the model policy, is it going to stay sustained or not sustained?
It will say on the,
Okay.
well, above, the investigative findings as to each allegation of misconduct, comma, to include sustained or not sustained. You do your form and it talks about a description of the allegation. Most agencies are not going to have a single allegation. They'll have multiple policy violations. So whatever box you have has to contemplate numerous violations. Pretty normative to have 3.
Plus.
Oh, yeah, like an add more.
Yes.
Yeah. Okay, I'm
That's
thinking
right.
more like the contents of the drop down that they select.
You'd have the
Yeah.
ability to add as many as 5 allegations
Yeah.
or so, and only 2 of them be sustained and the others not sustained or whatever.
I did anticipate that. I did kind of envision the form having, kind of starting off with officer information, current department information, including the service start date and appointment type. And then going into misconduct information where there's a selection of whether or not it's administrative misconduct or criminal misconduct,
Or both.
or both.
I think the criminal reporting is completely separate from that.
Yeah,
We're just dealing with
yeah.
administrative right
Yes.
now.
And because this is the E1. So we're kind of merging an E1 and an F5 together here.
No,
No.
we need to keep those processes distinct, I think, right, Joe?
E1, the arrest reporting. to
Well,
people.
because E1s can still happen outside of a separation.
And on a separate timeline, so they need to be a
Yes.
separate document.
But in this situation, are they, where they're filing a misconduct report because of a criminal charge, are they also going to send an E1?
Yes.
They will be separate processes reported separately. The administrative investigation has to be concluded on a certain timeline, the criminal does not.
That's right.
So
Okay. So does it make sense for the form to include a designation? This is a administrative misconduct or a criminal misconduct?
I say no.
Yeah.
this form is only administrative.
But I would like to know where criminal charges ultimately filed. That doesn't hurt you. It doesn't hurt your process, right?
You could have a checkbox, is there a parallel criminal investigation, something like that, but it should be reported separately, documented separately.
On a different timeline.
You can
That
have
helps
a,
us tie the two together when we're asked.
Don't we already have a reporting process for criminal charges?
Yes.
If there's an arrest.
Yes.
Right. So would we be reporting anything less than an arrest?
On this, yes.
Yes.
So we would be reporting criminal allegations without an arrest?
Well, not everything in the misconduct investigations is criminal.
So you want reporting of something less than an arrest if the criminal nature, that's what you're saying? No, that's what you're saying. That's fine.
What I'm saying is the legislature has required that we.
I know, and
report
we
this-
already have a
investigate.
reporting process for criminal charges.
Right.
We already have an independent process of how to report that to you. Why are we blending that with
I
this?
think because the processes move on different timelines. For example, I just reviewed a case where we fired an officer because he's got a criminal case on the federal side, which is taking forever, which that won't be concluded. He won't be arrested until that's done, but we don't want to have him on our books anymore.
you still did an administrative investigation related to those allegations, right? Anytime your officer is accused of a crime, that's going to trigger the requirement for you to do an administrative misconduct investigation, which you'll report on the administrative form. And then, Chief, you're right. That's what I was saying. If they are charged with a crime, you would report that crime separately. We're just saying the administrative portion, which is now required that you investigate, you would have to submit.
Right, because
In your case, you fired this person for some rule in your policies that fits the situation he's in with a criminal charge. You did not fire him for violating federal law X or Y. You cannot convict him of it.
Right, because that,
Right, right.
that's still
So
ongoing.
your roundabout way is a administrative. You're not firing him for a criminal violation.
Right.
You're firing him for a rule violation that it has its basis somewhere in a criminal charge somewhere else. So, but I guess at the end of that, the baseline of that is that you're firing him for an admin. You're not firing him for a criminal allegation. And what we're saying here is what I'm suggesting, we already have a process by which we report charges. Here, why are we trying to bleed that into this here?
I don't think that's what we're saying is to keep them completely separate. Now, perhaps just a box on there that says, is this related to a criminal investigation? Or is there were there criminal charges filed, simply so that if a future administrator is looking at this, they know, oh, I need to go look somewhere else so that I can review that for one to see if it was substantiated criminally or if it was not. Because you always have that circumstance where, say, an officer was arrested for something and the department ended up firing them, but they were acquitted or it was dropped or something like that. That's relevant information that a new chief or new sheriff that's looking at hiring them can look at this administrative side and look at that. But then a year later, they were acquitted, more information came out. They have at least I need to go look over here. It's a yes checkbox. Now they can go look at that. So they know that there is something more than what's in here, especially if it's delayed, like in that case. So they're separate and there's no information on it except to say, hey, this is related to a criminal.
Because in this circumstance, if we just did the whole misconduct thing and that checkbox didn't exist, you might not have any idea that he's under.
All you knew is that it was some rule violation and you knew nothing else and you didn't know to go look somewhere else.
So, somehow it alleging indirectly to a criminal charge or chargeable offense without there being one doesn't seem right.
That's not what we're saying. It has to be a legit criminal allegation, a criminal investigation that's being, like this case,
but you're right, there is.
and I'm not saying
And
that there's
what I'm saying is
potential
there
for
already
it.
is a reporting process for that. But this whole idea, the whole reason we're here is to start stamping the licenses of the TICO licensed personnel with an entry that, hey, you know what, this came up. The whole background on this is, you know what, some of us are getting away without necessarily reporting some of these things, right? So criminal charges, we already have a means for that. Okay, admin, this is where we're at.
Here's where I disagree. There is an avenue for criminal charges.
But we
There's
don't-
not
we don't-
currently an avenue for under investigation criminally as we speak. So if I'm the hiring entity and Jessica's under criminal investigation, I need to know that your reporting post-arrest helps me none.
But wouldn't that be in TSA, in Secure Share, that you brought this officer in, which I'm sure y'all did at some point, to address the criminal investigation that you were notified of? And all those things that went on prior to the termination, all the detail would be in Secure Share for the prospective agency to look at. Like, this is a totally separate, quick look that replaces the F5. This isn't supposed to be the place where they decide if they're going to hire you. That's Secure Share.
And now I've lost track of what we're talking about. Is the question, should we include a checkbox or if the person is under criminal investigation? Is that all we're talking about, or am I missing it?
Yeah,
That's all we're talking about.
Your point, I think, again, it's just a quick form to let you know if you need to dig deeper. And that's why I would say, hey, this lets you know, do you need to go and look elsewhere? Because this was, while it is it was a rule infraction that seemingly, and so, but do you need to dig deeper? Was it related to a criminal investigation? Yes or no? If it's checked yes, I need to go look deeper. If it's checked no, well, then it was, person they're tardy too often or something like that, because it's a small violation that's in the rule book somewhere.
So what constitutes a criminal investigation?
Case number to check out if there's, it's not if it could be criminal, it's if there is legit a criminal investigation.
So all of us work with state and federal agencies. Some federal investigations. How are you gonna qualify them?
Well, it's a simple question. Is this related to a separate criminal investigation? Yes or no? It's a pretty straightforward question. In your case with this, if you were filling this out on that officer, obviously it is related to it. Either is or it isn't.
Right, and it captures ones where we don't already fill out that form because he has not been arrested or charged yet. So
Yeah.
that exists for one that has occurred, but this would capture the ones that are not to that level just yet.
Yeah.
I mean, I don't disagree with it necessarily. I just feel like it's overkill because the description of the allegations, investigative findings, and any detail that you put in there, I feel certain that if that's the case in your situation, that somewhere in that summary report, you would say this officer
that's
is
fair.
under criminal investigation.
Fair.
You know what I mean? Like, I just think the more check boxes we have, especially in the large agencies where, and we'll get into this, I'm sure, you know, this is gonna be the way it's written right now. This is a tremendous amount of paperwork, and check boxes and all kinds of things.
If it's got the small narrative brief deal that you talked about, I mean, there's your opportunity. That's fair too.
Because that would be the crux of why that person was fired.
You gotta drive 6 hours. So I'm gonna take off.
Okay.
So what happens, but then like your scenario, because we had one in Dallas. The feds came to Dallas and said, we got one of your officers under investigation. That's all we can tell you.
That's exactly why that checkbox needs to exist.
Wait a minute. All it is there is no anything other than the feds came to us and said, we've got one of your officers under major investigations for a capital crime. They didn't want to just tell even our chain because of leakage, right? All they wanted to say was, you got a guy under major investigations for a capital crime. He's a Dallas police officer.
Did you guys conduct any misconduct investigation based on that?
How? On what? We have
I don't know
no
that.
investigation of experience.
All of this.
There's no obligation then under this.
Yeah, this one.
By the feds saying we have a person, a police officer under a capital crime.
I would say that's an allegation of a federal
Yeah,
state.
and it
law.
would
But then how do
trigger
you-
this model policy.
But they wouldn't even tell us to the extent of the investigate. We need to call the officer in and go, hey, guess what? Their thing was, don't tell the officer, right? So you can
What's
just,
your question?
well, I'm just questioning as to, when you talk about the feds and the way they drag their feet and all this kinds of stuff. You were notified by the feds, this guy was up on charges or something. So you bring him in and conduct your own investigation. You had the knowledge and knowing of what he was up against, right? Is that true?
Mhm.
Okay, so then you conducted your own investigation, whether he's cooperative or not, or whatever, you decide to just terminate him. The feds still are, I guess, the case is not disposed of yet, but he's still out there.
Yes.
We do in the scenarios of like what I gave you there, where does,
Wouldn't conduct an investigation until I had more information. I would not do a misconduct investigation based on what you told me, so this would not be triggered.
Can I give an example where it would be one we're dealing, a recent one where we had feds came in, did a child porn search warrant. The target is not a peace officer, but their spouse was. During custodial interrogation, the spouse admitted to knowledge and facilitating the crimes, but was not charged at that time. The chief says it was really embarrassing, so I let them resign. I forgot to mention that to the other chief. They didn't disclose it in their PHS. The other agency claims that they hired them with no knowledge of any of this, and it was never documented. Those are the things where I think the first chief's knowledge requires him to conduct a misconduct investigation, right, administratively, and just check the box that there's a parallel criminal investigation. So when it's not disclosed by that officer, the new hiring chief knows I need to find out who that agency is and make inquiry. Whether they'll give it to me or not, I at least know where to look. That's all that checkbox is doing, is steering them. It's just like NDI. It's a pointer to tell you there may be additional evidence here if it wasn't disclosed in the PHS.
Right. But I think now they wouldn't be able to just let that officer resign because they're embarrassed. I think this policy says if there's an allegation of a federal violation, they're gonna have to bring.
I agree. That's what I'm saying is they have to conduct a misconduct investigation and they should check a box that says that there is a parallel criminal investigation so that someone knows where to look for that piece. Because I'm certain that chief would not have revealed the details of the criminal investigation in his summary.
again, this is for hiring.
Maybe not in the summary, but in the in the secure share where the entirety of the investigation is, it would be in there.
Unless you're in the provisional period and they haven't finished it.
Yeah.
And I would sure like to at least know that there is an ongoing criminal investigation.
I don't think a checkbox is a big ask, and it does help.
Checkbox.
Okay.
From my perspective and being asked by Sunset to provide data through our process on the whole picture of from what have officers had misconduct on and what was the outcome? Well, this having a report requiring the data come to us in a prescribed method that we can run data against allows us to give that full picture of.
But I don't agree with the full picture, because what the problem with the full picture is, a lot of the criminal investigations have to do with an officer involved shooting, like the chief pointed out, which is not, that paints a different picture. You know, you might be under, you know, you're going to be going to the grand jury or whatnot. Of course, there's a parallel criminal investigation ongoing. A lot of those are procedural, and I would hate to see the data produced by that kind of record that, look, all these officers are under criminal investigation. Well, a lot of those are probably procedural.
But we wouldn't know. We wouldn't be able to tell that if we didn't.
That's
That's her point.
But that's my whole point, is that unfortunately, a lot of the data that's going to come out of this is not going to help officers.
She's
So
saying it's
we're-
an automatic negative inference. Every
Yeah,
criminal
and that's a fair point too, because it goes beyond officer involved shooting, custodial deaths,
Yes,
where
like
you would,
so
where you
many
would
things.
have a criminal investigation along with an administrative when they're going in there. That's a fair point. I still would capture data, but how do you delineate that down? That's a big chore.
Let me also, I'm wrapping my mind around this as well as I speak, but these are submitted upon separation. So in the officer involved shooting scenario, you would have some idea of good shoot or bad shoot based on whether they were separated or not, would you not? But I think she brought up the data point is, even though they're only going to be submitted at separation, if Jessica in a large agency fires someone and submits this report, well, that officer may have been a good officer for 20 years, but maybe there were some other investigations that occurred. She's going to have to also submit any other investigation that occurred during that time as well. So you're not just capturing the one investigation that occurred upon separation, you're capturing every investigation. Again, the way it's written right this second, we don't make any changes today. That's a lot of investigations and a lot of data.
But we've been doing 143 cities, especially with Secure Share. We've been doing that since the inception of Secure Share. You get all of them.
Yeah, but not in this little database that we're talking about that we know very little about what it's going to look like.
In Secure Share right now, it's just like gobs of PDF files that you can't mine. And doing this allows us to make summaries of the data or actually
Which we
derive
probably would
information
recognize as
with it.
counterproductive.
Yeah.
It can be very counterproductive.
We understand your point. We disagree with your point on wanting to make it data mineable. That's probably not even a phrase, but I just made it up.
Form, though, in the
Such as prescribed format.
In a format prescribed by the commission.
Okay.
Correct.
So at first I was fine with the checkbox. It didn't feel that bad, but I do recognize your point, Jennifer, that if there's criminal allegations, it's probably going to be captured somewhere else in whatever it is we're submitting. And B, it does allow for that data to be mined and then collected. And then we have all these officers that have resigned with a criminal allegation, when really it is just grand jury review of an officer involved shooting or something.
Or it's an overzealous district attorney somewhere nearby. And now this officer has a permanent check mark on that summary report. Nobody wants to touch him, when in reality, if they went and actually reviewed the actual documentation, they would realize, oh, this was political to begin with.
And back to his point, if there is ultimately an arrest and this person is going to be licensed and apply someplace else, that will be captured on that other form.
So did we talk ourselves out of the checkbox? TJ, you going to argue for it still?
Your point is if it results in arrest. I will say that one of the most frustrating types of enforcement investigations we have to do has to do with honesty in a personal history statement. And some of those cases result in criminal charges and criminal convictions, which is unfortunate, but some of them are necessary. And the most commonly and most serious exclusions result to your participation in a criminal investigation, whether you've been stopped, interviewed, what your conduct has been outside of work most of the time. I agree with your concern. It is a very real concern. How people are going to take the data on how many criminal investigations are tied to officers. That data exists regardless of whether or not we put it in the checkbox. It can be built and studied, and people can draw their own inferences. It can be presented in a positive and a negative way. I don't know how you differentiate that. But what I will tell you is if the goal in all this is to help chief administrators make the most informed hiring decisions, that you need to give them the data points that they may be missing in other places. And I hate that it often results in people getting hired, then it's discovered, then I become involved, we revoke their license, we charge them with a crime, and we go from there when it could have been captured at the time of hire.
I think that might have a tie into the provisional triggering of notifications that we talked about at 1.2. I need to be able to tie a misconduct report to an E1 if I need to. I think and then the triggering of.
What's an E1? You keep throwing that around.
Oh, I'm sorry, that's the
report of licensee arrest or indictment.
You might have to do that on the back end anyway, because the investigation can be by one agency and, well, the administrative could be by one agency and the criminal could be by another agency.
Yeah.
So we're still on summary report, right?
We are.
I understand the challenges for T-Cole and the fact that you guys have to capture certain stuff, but ultimately, I care about how this policy guides police departments and how they're doing their investigations. And I think I'm now team no checkbox, because I think that the description of the allegation or the other bullet points that we have will sufficiently capture that information if done correctly. For example, in this case, our summary report says that we were made aware of this criminal activity and started this investigation. So we get to the same place, I think, without the checkbox.
Jessica, for your sake, what if instead of tying a misconduct investigation to an E1, we tie an E1 to a misconduct investigation?
Well, we won't have the misconduct report until after separation. The timelines are so different, but
yeah.
I'm good with just removing the criminal checkbox.
Well, the reality is it's your all's discretion, because the law says that the form is designed by T-Cole in a format designed by T-Cole, what you just read. It's your all's discretion, not ours. We guide the agency, you all design the forms. Am I wrong?
Right.
It's really not our decision.
Well, we want to but we want to take input from the committee for sure. You guys
Well, we're probably equally divided.
we'll certainly include the
I don't think we are.
definition that the dispositions we defined here can be included.
I think we've got the summary report definition narrowed down.
Yeah, we were only on the checkbox, the additional checkbox.
What about you over here, this side of the room? What's y'all's thoughts?
I don't have a problem with the check. I don't think it's an unreasonable ask, and we're making assumptions that in the description or narrative or whatever area that we're saying this people are gonna put the information in, that they're gonna do that. I don't think we should leave that up to chance.
To go back to what you were saying earlier with many different ways that it's classified, like you were saying that you had like 4 or 6 different ways. And so the same thing with DPS, we have multiple different ways. And so actually with the checkbox, it makes it a little bit easier on us.
We'll look at it and talk about ways that we might be able to capture it, but make it more relevant data than just mass data. Let's bat that around for a little bit.
Definitely take that into consideration.
What if instead of criminal investigation, the question is, were criminal charges filed, yes or no? Because then there's going to be an E1 and
We don't need that because that will be captured.
Okay, then maybe there's no need.
Yeah,
Great
but you,
idea.
yeah, you capture it, but how do we get that info on the E1? We don't necessarily get the E1 info when I'm doing the background investigation.
The E1 should be part of whatever is delivered to a hiring agency.
And there is the requirement if criminal charges are filed. Remember, we have admin reports.
Well, I guess I've never hired anybody that's been arrested, so I guess why it's probably.
Good, we like to hear that,
It's great news.
which is why, yeah.
Making your life simple.
Right, but we also have under this, the scenario for those criminal charges when filed, as it states in there. So that summary report exists there too.
In the simpler sense, it should be, that's why we're requiring everybody to be printed now, right? To go through the electronic printing process to get that hit. So
All right, are we done with summary report? Did not land the plane on a box on criminal charges. We did. You said no, some said yes, some said it's not a big deal.
It's not in our model policy.
It's not in our model policy, that is correct. All right, let's go under investigation. I am reading comments on number C, 3C. An investigation into alleged criminal misconduct for which criminal charges are filed against the license holder to the commission in a timely manner. Attorney says, what's a timely manner? Question is valid.
Yes.
Based on the facts of the.
So
30 days.
it can't be 30 days. Good. Great. I don't know what world you live on.
I understand the concern, but I'm not sure we can prescribe. This is different.
It says it's after it's complete.
After it's complete.
So give it 20 days.
Yeah, y'all have the ability to set that deadline after the investigation is complete.
It's not prohibiting a long investigation. It's just saying after it's complete.
Right.
Send it to us. Give me a day.
Investigation can last 2 years. Use that example. As long as you submit it X dates.
He's got to get land the plane. They got to get the information.
Okay, so what is T-Cole? If there are criminal charges filed, what's the time frame that you want that reported to T-Cole? Because right now, it's timely manner.
30 days already, isn't it?
That's for, no.
I don't think this replaces that. I think this supplements that, right?
Correct.
This is charges filed, maybe not an arrest yet. This is going to grand jury at some point. We filed it with the DA's office, it's in their wheelhouse. How soon do y'all want to know about it? Because it says timely manner. The attorney's saying, what's a timely manner?
When does the form due for after an arrest?
7?
No,
30.
30 days.
30 days.
Yeah, I mean, we did 30 for.
30's throughout the whole.
30 days, so if the criminal charges are filed, you shall notify T-Cole within 30 days? James? 30 days?
Sure. 30 is great.
So instead of in a timely manner on C, it will say within 30 days after the investigation is completed.
Is this an additional requirement by statute?
Yes.
Yeah, they have to.
Yes. This is the admin misconduct investigation requirement, submission, that y'all decided within 30 days after separation for all the misconduct investigations. There's the criminal misconduct report, summary report that's due. Now y'all decide 30 days after that investigation. Does that make sense?
I think so.
It's separate from the misconduct, the admin side, admin misconduct, and then there's criminal misconduct.
But it's going to be the same summary report, right? It's the same form. No.
That's the thing. I think it'd be very similar and I think much simpler and straightforward. Yeah.
All right, are we on D? Back, go ahead.
One note on the introductory paragraph under investigation. The first sentence says this agency shall investigate allegations of, and it has the modifier serious in front of misconduct. I would suggest deleting the word serious because that's nowhere else. And you've already defined misconduct. So what's serious misconduct? I think that's a vestige from when we were discussing. I don't think it makes a material change other than serious.
Oh, get rid of serious from misconduct. Since we just defined misconduct.
Yeah, but are we about to rehash that whole conversation we had with Jennifer?
Well, I know why it's there, because that was the legislative intent of the definition of misconduct. But I guess we still have more conversation to go. But I understand the point
Right.
of what you're saying.
However y'all define misconduct at the top, I think is sufficient to indicate what misconduct is investigated here.
Right.
We could just say strike serious and add misconduct as defined by this policy.
Well, to John's point, it's already defined above. All right, so any dissent to striking serious under 3 in the very first full sentence? Going once, Jennifer, going twice, sold. Not having enough time, serious is out of it. All right, D. Here's the question. So it reads, complete an administrative investigation of alleged misconduct and prepare and submit to the commission a summary report on the investigation, including the disposition of the investigation and any format prescribed. If we are going to require a template, if y'all are going to require a template, let's just say that now. Not in a format prescribed by the commission, but instead on the template provided by the commission. Because y'all have already said you're going to do a summary template. Is that accurate?
Love it.
Yes, and then including the disposition of the investigation and any informal findings, that would be stricken, right? Because we've already defined what the summary report would include above.
That's not fair. The law is.
Let's check that.
There is a definite, or there are. But we've already addressed that in the definition of summary report above.
Yep, you've already got it in the summary report. In the definition of top.
Is they're going to do it. Did y'all resolve whatever y'all were talking about?
Yes, so I think we're in agreement that we will strike including the disposition of the investigation and any informational findings.
Is this going to be on the template?
Right.
Correct. And we've already defined the summary report above.
Got it. So it's just redundant.
Correct.
So it's going to read, Iris, complete an administrative investigation of alleged misconduct and prepare and submit to the commission a summary report on the investigation, comma, or y'all probably want to clean this up, but it's going to say on a template provided by the commission in a timely manner, but not later than. Y'all can clean up the grammar. Agreed? So Julia said the same thing. I'm trying to differentiate between misconduct under this policy and other misconduct. That's why we defined it. Okay. Any questions or issues on E or F? E is gone. Why? Include documentation of the investigation and describe. No, that's totally different. Yeah.
The only thing I want to just make sure we're clear on, Chief, is the misconduct allegation summary report will be completed regardless if the findings are sustained or not sustained.
Yes.
E talks about
Yes.
a copy of the summary report going in a personnel file.
That would only be sustained, right?
Right.
And I agree. I've got notes on that right here. I agree with you. It needs to also reference or as described by section 17, and of course we'll do conforming Texas Occupations Code 1701.4535 or 1701.4522 is applicable or something along those natures to indicate that that's
here or here.
either one,
Right.
either one, right? It indicates both of them. Yeah, either or. It's either A file or G file.
Right.
Because this makes it sound like there's only an A file here.
Right.
Good catch. Okay, I caught my notes up. All right. Let's see. Summary report, what?
I'm sorry.
F says submit to the commission each report of completed investigation. But we've already said in D, you would submit the summary report within 30 days. So I don't think F is necessary.
Yeah.
And then jumping down to A, we've kind of already addressed.
It's repetitive as well.
The whole section is in there.
I think so.
Why? Where does it talk about appeal? That part's not in there.
But the 30 days.
Yeah, A is repetitive. Y'all agree with redacting A?
Yes.
But B, I don't. Gretchen, did.
Yeah, you're right.
Okay, cool.
Title summary reporter should have a different.
If we're striking A, would we call that appeal process or pending appeals or something?
C, would be in there. That's not anywhere else, is it?
It's in D,
Yeah, it's
3D.
Oh, okay.
And we could reorder all of this. We don't need to address the 30 days multiple times. We don't need to address submitting to TCO multiple times.
Yeah, we should call it something else since we already have.
Yeah.
Or if the appeal provision is the only unique part of this current summary report section, we could strike everything else and just make your current B under summary report your new F.
Oh, good idea.
Sure.
That's right.
Good.
Are y'all striking, you're not striking D, you're just making it the next letter then?
I'm sorry, yes, yeah, absolutely. That's what I meant.
So B becomes F, C gets deleted, and
Yep.
then D becomes G.
Took you a while.
I know. I didn't think about that.
I think, I guess the comment on B that's gonna turn, 4D that's gonna turn into G. It says an officer leaves during the pendency of an investigation of misconduct. A summary report shall be furnished, but it doesn't specifically say the investigation shall be completed. Language like that. Investigation shall be completed and a summary report shall be furnished.
Feedback?
Last line.
Okay.
So let's say that the job.
Oh,
But
yeah,
Yeah.
3A addresses that, right?
Okay.
I almost think that we should have 3 investigation and then 4 the reporting, kind of, because 3's investigation is getting a little bit long now, and talking about investigation and summary report to TCO and appeals, break that up a little bit.
I think that's a great idea. Yeah. And here's another point too, as we go through this, that formatting we were talking about. I know we use Roman numerals on one, numbers on another. We will conform that consistently across the board and make sure everything is referenced correctly, the whole 9 yards.
But to Aaron's point, that's a great point. G has got to have a provision. Remember, we need these to be instructive. Stuff is not intuitive for new chiefs. Yeah, you still have to complete the investigation.
And there are still some questions about that. And if it's not explicit,
Exactly.
yeah, I tend to agree with that. Even though it does say we'll complete it in a timely manner, you're still gonna have a lot of people that go, man, but it left. Why would I? Well, it's completely left. No. You gotta complete it. Render findings, and then submit the report.
Would it be confused?
I mean, it's in the statute.
Yep. I just put on here, Iris, if an officer leaves during the pendency of an investigation of misconduct, comma, the agency must complete the misconduct investigation, comma, and a summary report shall be furnished to TCO regardless of the findings. Yeah, it's in the law.
Instead of must, we say shall, because again, this is gonna be a model conference, not an instructor. I get your idea about instructing.
Shall, oh yeah, that's fine, shall.
They gotta send the summary, do they need, but they still have to send the entire. Of course, they gotta send all of their records anyway. So that's, all right.
So on 4B, as it stands now, 4B, not the revised, but the B, Julia writes, This is a huge cost to agencies and restricts employers from negotiating exits. Not telling you something you don't know, but requiring all agencies to undertake an appeal is a huge burden for an agency. All we are trying to do is put the employee in the rearview mirror. I don't think it says you have to do the appeal. It just says shall not be considered complete until the appeals are final. I'm not sure what her point is on that. She may have been drinking a little bit more. Complete until all appeals are final. The agency shall notify. Am I reading it wrong? I don't see that you're obligated.
All the appeals available. Yeah, I don't know where she's from, but
Yeah,
Reading from where
We were right here on appeals.
didn't we decide to strike all that?
No, it became the new, but it's not gonna be a new 4 and then
Okay.
some other number.
letter.
And I think the interplay, and Gretchen's making a good point, the interplay with appeal in this policy is really the important thing it's pointing to is the submission. And when that submission requirement occurs in the next department's able to see that.
Yeah, so it's not considered complete for submission to TCOL until all appeals are final, right? Is that?
That's right. That's right.
Maybe just making it say all appeals are resolved would solve the problem because you don't have to have a final appeal. If you agree to a settlement and you both agree to dismiss the appeal, it's resolved and now you're done, right?
Right.
That may be where she's hung up. It's saying appeals are final. They don't want to have to go through finishing an appeal.
oh, sorry.
That's a good point. So,
Just change it from final to resolved.
yeah, that's good. Resolved.
Do we need to
Get that ours.
talk about the appeal? It says that they're required to notify TCOL that it's under appeal, but what about requiring that information is also notated on the document, on the summary report itself? Or is that?
I don't think we would get it. Maybe I'm had a lot of model policy talk today. Maybe the appeal, you won't get the misconduct report or the A report while the appeal is pending. So what would indicate that
For the summary report. So a prospective agency looking at the summary report, that it would be noted on there somewhere that it's under appeal. So this just says that the agency has to let you all know, but it doesn't explicitly state that it's going to be on the summary report itself, that it's under appeal.
I don't think we would get it, or I don't think the database, it would be in the database while the appeal is pending.
Because it's not considered complete.
Correct.
Well, no, I just mean so that the prospective agency knows that when they're looking at the summary report, that what they're looking at is under appeal.
I understood as we would go ahead and submit it, but notate it was under appeal. But if that's not the case, we need to clarify that it wouldn't
We
be
would note,
submitted.
it says that we're required to notify TCOL, but it doesn't explicitly state that TCOL would put it on the summary report forward facing for the prospective agency to see.
Don't submit it until the appeals are final. But what, just cut through it all?
And I'm good with that. I didn't think that was
Yeah.
on the table.
I didn't either. I thought it was, you don't submit the whole thing, but you have to submit the summary.
Of a completed investigation.
But it
So
has,
this is saying that it's not
Not
completed
complete.
until the appeals are resolved.
So how does that?
but the law says it has to be completed within 30 days of separation.
Yeah, this
You're
summary.
supposed to
report.
give something to the new agency on anything that occurred at the prior agency. And so if they're going through a 2-year appeal process, something that happened 6 months before they left, unrelated to their leaving, how do we resolve that? How does the
Yeah, that's
new
gonna be a
agency?
conflict, because if an arbitration takes a year and a half, well, it's not complete then. So how do you?
Well, I thought we had discussed this before, that it would just be noted on the summary report that it's under appeal.
The drop down on there with that.
Right.
Under
Or
appeal,
some-
yes or no?
It seems to be,
Yeah.
a notation. That's what we're looking at.
My only concern about a drop down, maybe Jessica can talk about this, but is for the agencies that are gonna have large agencies. The drop down in the digital form is gonna require them to do that for every single investigation. Not until that person separates, but they have to go back through all investigations that they've ever. That's a lot of. So anyway, I mean, maybe we're still going here, and maybe that's a different part of this conversation, but
But it would only be misconduct allegations going forward, right? So even if someone resigned a year from now, we're not going 20 years back and reporting that. We're only going from now, forward, right?
Correct.
In looking at the timeline moving forward, the effective date of this applying to all agencies is there's going to be a window of time after the final adoption of rules in April. Beyond that, where a statewide, and this is a discussion that you can have at the committee level, and I'm sure the commissioners are very interested in it, of when this will be effective and applicable to all across statewide for all agencies. So it won't be April, after the April meeting, this all kicks in. So there will be some time to work through some of these issues like this at the periphery and things that we haven't even recognized yet. But I think particularly the procedural matters, as long as I think the substance that you all are focusing in here on, I think that sets up everything very well to play out is whenever it does become effective, if that makes sense.
I look at this simply, if there's not a notation on the summary report that this is under appeal, how else will the new hiring entity ever know? They would never know. You've got to have that box.
We did talk about that.
Yeah.
And I had a note that, you know, if the misconduct report is not filed to us before the 30 days, the requirement to submit the file to us within 30 days after separation, because it's not complete, then we would have a notation that there's an appeal underway, and that would trigger the communication to any new hiring agency during that provisional period that, hey, there's an appeal that is either incomplete or we've got this flagged that there's a pending appeal, essentially.
but tied to what? Would they just submit to us that there is a misconduct investigation, but it is under appeal, and not have any other information?
I mean, no, my understanding was that it would be with the summary report, which was completed and turned in 30 days, and it would just be basically stamped that it's under appeal for the prospective agency to have that
Explaining why it may not be a complete summary report.
Agency would have to follow up once the appeal's
That's
done.
Yes,
Right.
that's what we discussed, yeah.
Chief Anderson might be able to help us with this, because I think what it's going to cause is it's going to cause most agencies to operate like civil service. Does your agency do like most of the big ones? If you indefinitely suspend someone, you don't separate them. You don't submit an F5. They go through the appeal process and they're indefinitely suspended, but might continue their appointment with you for 3 or 4 years? Is that how y'all submit an F5?
So do we.
Because a lot of the civil service agencies do not separate. They leave them in an appointed status until they resolve that. I'm just telling you what they do. And that's what other agencies can do, right? Because then that doesn't create the whole problem of the separation in 30 days. You can wait till it's resolved and report it all at that time.
But that's not in anybody's best interest, agreed?
But it also they wouldn't be seeking new employment. I mean, and if they were, then at that time, then they would have to separate at some point. I mean,
They don't have to. You can have dual appointments.
Mhm.
so you're saying a prospective agency would hire someone from another agency that is just pending,
They can.
and they would go into secure share because now they have to for the 87th, and they would see that and they would still hire them. Is that what
They could, yes.
that that's actually happened?
Mm-hmm.
Okay.
I mean, that's-
You'd be surprised.
It's remarkable. Little nest of.
So I'm with Jessica on this one. What's the key issue we're debating right now?
It seems kind of like a non-issue, but I mean, I guess if it's happened once or
You
something.
have to have an appeal box, agreed? On the summary report, you have to.
Yeah.
Okay.
Well, I think it was coming back to defining this, that, I think we were talking about B, right? We were saying it's not complete until all the appeals are resolved.
Right.
So we've created a situation where we're getting these misconduct summary reports within 30 days after separation, or if there is a pending appeal. And I'm sorry.
Yeah, but who wants to do it that way? isn't the first procedure cleaner, simpler? You separate, 30 days later, you get everything. Versus I'm gonna hang on to this potentially a year and a half under Greg's scenario when it's under appeal. Doesn't make.
So what if we just take out the first sentence? That's it? Yeah. I mean, I think that would work. That's just incorrect, first sentence. I mean, it might not be technically incorrect, but per. Feels like there's a policy- conflict though. Yeah, per the
Yeah.
policy, you have to turn something in 30 days. So whether it's complete in their mind or not, that's all the time they have.
It'd be easier. I'm surprised you just said that. You literally argued differently.
That's what the law says. I don't think that part is in my purview.
I would love to strike it.
If it was, I would.
Quick question.
Uh-oh.
Probably not quick. Let's pretend I've had 6 or 7 complaints going forward. I'm gonna retire. I don't intend to go work for anybody else. My agency will still now have to prepare a summary report on any previous investigation to submit to you guys.
No, well, yeah, I think that's, I think this is not retroactive, which y'all are all discussing.
Going forward,
I'm just using this for hypothetically speaking. Let's say the model policy of this and the other advisory committees, it's proposed, finally adopted, and we determine the the regulated community, the advisory committees, the commissioners, all to say effective January 4th, 2025, this is applicable to misconduct and or separations. I'm just using this to demonstrate after the effective date of the advisory committee model policy and the rule. Does that make sense? So there's no retroactive. We have to go back and do
sure.
200 instances of misconduct, sustained or unsustained, whatever the case was.
That date forward, my agency will have to complete this form on any investigation going forward.
That's correct. That's their
It'll be
obligated to do
submitted
so.
when the person
Or they can
separates.
submit it at the time. Makes-
They can, or it can just,
No later than separate.
That's right.
I think the issue is you say, okay, I'm not gonna work as a cop again, and then 2-3 years from now, you say, okay, I've changed my mind. The documentation's still there if it's been submitted.
That's right.
In 3 years, whenever you go be a court bailiff, there it is.
Which wouldn't be a big deal if our definition of misconduct wasn't as broad as it is.
right, because this is now another form that we're gonna have to do for people who may or may not retire to go work someplace else or separate to work someplace else. And that's kind of my point. If I have no intention of going to work anywhere else, this is an extra burden on the departments to capture all this information to satisfy.
Well, it'd be a form you do on any, like, you do the investigation at that time, I think you do it right then. And I think that was to the
Yeah.
point over here too is, so you've done this 7-day investigation. You don't want to do another whole day's worth of work on the summary, another 10 minutes on the summary, and it goes with the investigation. So that then whenever the person does retire in 2028, they've had 2 investigations in that 3 years. Well, it's two things that you don't have to go back and look for when did they retire if it's done right then. And so it takes 10, maybe 15 minutes, 10 minutes, whatever to
Or
do
you
on
do it
top of
in
the
F5.
investigation. Yeah.
That you don't have to do it
There you go.
anymore.
F5's changing now. Yeah. I'm just thinking for the bigger agencies and DPS too, this is going to be a different level of work than for your
Oh, yeah,
agency.
totally agree. But we knew that going into this.
And that's why the law contemplates varying jurisdiction sizes, et cetera. Which this,
And we've significantly changed the definition of misconduct from the way they defined it in the bill, which allegation, one of the things that it says in the bill, other than the sustained, unsustained, which is a big one, is, and we contemplated this in the beginning, with a violation of a policy for which the agency may suspend, demote, or terminate. To me, that's something that we should consider putting back in to narrow down the number of investigations that you're required to complete. Because, and the other people have pointed this out as well, that a lot of these, unlawful allegations of unlawful search, excessive force, almost all these allegations a lot of times can be squashed immediately looking at body worn camera on the supervisory level, and it's done regularly. So if we don't narrow this down, at least, I mean, the only thing I could, is I've talked to several other committee members and members aren't not on this committee. I mean, it's not easy because these two policies are intertwined, but to me, that the way they defined it in the law, where it states the agency may suspend, demote, or terminate, could be a way to narrow that down, because an agency is not going to suspend, demote, or terminate an officer who, the complainant lied, and it was squashed immediately. So that would encapsulate those, and they wouldn't be required to do all this. Because right now, the way it's written, anytime someone alleges that you were excessive in your handcuffing, this whole thing would have to take place.
But then your summary report would say it was unfounded. There was.
I know, but it's not about that. It's partially about that, but a lot of it's just about the bureaucratic policy. What's going to have to take place there, when normally that's literally a 5-minute ordeal that a supervisor deals with on that level.
And when you say squash or deal with, that is essentially an investigation.
Yes.
But that doesn't rise to this level.
Yeah.
You still have an allegation and you still have a final disposition of the allegation. You're done.
Well, no, because if I'm the desk sergeant, somebody comes in and says Jennifer did forced handcuffing, I will look at her body camera to see that it did not happen. And that would be the end of it. I'm not going to go through the whole thing of a formal investigation.
This doesn't say it has to be a formal investigation. If you classify them differently at your agency, that informal investigation, as long as you document what the allegation was, what the final finding was, we took everything else out. That's what she just described.
To do this form.
Right.
Yeah, and the number of times this occurs is insanity.
Would have done anyway.
Yeah, it's to me, it's way excessive, and
Informal investigations.
it definitely goes way out of the bounds of the legislative intent, with no question. That anybody here that was in the meetings, this goes way out of bounds as far as the definition and the number of investigations and submissions. Submitting every single low-level allegation that came through to TCOL was not the spirit of this legislation. It just flat out was not.
So what would you do to change? I mean, I think you could argue that the way the legislation is written is broader than this. But that aside, how would you tailor this to exclude the type of alleged violation?
That's what I was saying, is that I think one way to do it would be to go back to the bill's definition, where they talk about a violation of agency policy for which the agency may suspend, demote, or terminate. Because then if you have an allegation that was immediately unfounded by a frontline supervisor, by a body worn camera, which has been thrown out a lot, because that's how we refute a lot of these really quickly without having to do all this. And it happens a lot. This isn't something that if it rarely happened, this wouldn't be a big deal, but it happens on a daily basis. I think that could be a way that an agency could interpret it that, well, I don't have to go through all this because this isn't something that I would suspend this officer for, or demote or terminate.
So under 3, we have may result in suspension, demotion, or termination. Would it be better to move that provision up to the definition of misconduct?
I thought we went round and round on this with Victor on
May
before,
result in suspension.
whether the allegation is something that could result in, not whether the findings. Right?
Say that again now?
That's what the definition.
Whether the allegation is something that could result in suspension, not whether the
Does that
findings
help?
could result in.
I think it would.
You have to
Here.
investigate anything with allegation is something that could result in a suspension. Excessive force is something that can result in suspension. If you figure out it clearly didn't happen, you document it. Move on.
Well, but the law does specifically say a violation of a law enforcement agency policy. It doesn't say an allegation of a violation. It says a violation.
The problem is, and that's why a lot of these questions came up, the misconduct definition was defined in the bill and we've changed it. Because we had to essentially to merge these two concepts, that we were going to have a model policy on misconduct investigations and when they're reported to TCOL. If those were separate, we would have a completely different conversation.
Now, Jennifer, I agree with everything you said, except the provision in the law specifically says misconduct means a violation of law or any of the following that have been sustained by a law enforcement agency. And
Well, I'm
all
not
those
saying-
examples you said, we didn't sustain them. So
I'm
those
not
are-
saying that we adopt the entire definition that's in here, but I do think that I would help us narrow down some of these misconduct investigations that are required currently, because I think that agencies could interpret that, or maybe they could in their agency policy even kind of lay out that, because we talked about how, every agency policy is different. So, it may be a way. I just don't see how this number of investigations that we've addressed here.
But then
Gonna be
we
reasonable.
talked about this, and so go down to 3. Specifically, it says this agency shall investigate allegations of misconduct that may result in suspension, demotion, or termination at the time of the agency. So we did. We have exactly what you're asking.
Yeah, but not in the definition of misconduct.
What?
And see, let me do the first part of that, which you're correct. That's what misconduct is, but I also want you to keep in mind too. This is from the statute. Agency is required. That's the word that's used, required to initiate investigation into quote unquote alleged misconduct of an officer employed at the agency at the time the agency becomes aware of the alleged misconduct and complete the investigation in a timely manner. And then when we talk about alleged misconduct, and that leads us to the definition of misconduct. So allegations of a violation of law, allegations of a violation of law enforcement agency policy, which the agency may suspend, demote, or terminate a license holder. So I hear what you're saying about the scope of it, and I certainly think there is, for the purposes of a model policy, you can highlight. When we're talking about violations of law, are we talking about if there's been a Class C misdemeanor, or does this include things that would cause action to get your license, or does that only include felonies? I think that's the type of discussions you all have, but excluding or narrowing what misconduct means, I don't necessarily know less than this. I don't know if that can be done by the committee.
Would it help at all to, in our definition of misconduct, it says alleged violations and alleged conduct, would taking out the word alleged help at all, or no?
Business came straight out of statute.
You can't.
Through the statute that it's alleged.
And I completely agree with what you're talking about, because and most of us come from, somewhere we have experience. We have formal complaints and informal complaints. And I know, like TJ said, it doesn't talk about that in there, but someone that sends in an email complaint that Officer Smuckatelli did, whatever, put me to the ground and didn't need to. And that can easily be handled and everything. As opposed to the formal complaint that someone fills out and signs, like what 614 requires, and that does trigger the formal investigation, but at least it's a little bit ambiguous where the law says any allegation of misconduct that we shall investigate it. Maybe that's something to clarify later on, and after we go through this with the legislature, but neither here nor there. I think that 614 offers clarification right now that if it can't take action, if it's not a written signed complaint, that offers some guidance already in it. But if we have that written signed complaint, an allegation of misconduct, and I got these, late looking at it, but I'm just reading this where it says includes any of these things right here. And I look at these and I think that if any one of these were sustained, certainly an agency could suspend somebody, they could demote somebody, they could terminate somebody. Doesn't mean that they will. They may very well find out that it didn't happen and they're exonerated. And so, but even then you've got to file that report that says, or that summary. And so I don't know that there's an easy answer for the one. And I agree with you. I don't think the intent of the legislature in all of this was that someone that makes a frivolous complaint because they're mad they went to jail, that they want to trigger all of this stuff. But then again, a lot of the written signed complaints are also frivolous. Nonetheless, they absolutely were clear that that shall be investigated. And it'll end up being exonerated, but we'll file that.
But I think the reporting to TCOL was the part that, again, the intent of the legislature wasn't necessarily for those two things to overlap.
Yeah.
And we've been kind of pushed into this one policy where those things overlap. So that's what's made it difficult.
Sure.
I did pull up 614 earlier because the email that I had sent John was that maybe we should put 614, 022 and 023 on here, which talk about the complaint to be in writing and signed by the complainant and the complaint to be given to the officer or employee, that should be explicitly stated in this policy. And then I guess, yeah. Yes. To in order to meet this threshold of alleged violations. And that would narrow it some.
I agree with that because that's when I provided that stuff, that's the TPCA policy on what does the formal complaint in our agency. So all those things listed in there, if you write that down and you sign it and that's your allegation, that's what starts that process.
I would be fully supportive of that.
I would too.
We do the same
It's
thing.
in there and there's no
Complaint.
It answers some of that question, I think, that you're bringing up.
I think it would eliminate some of them. Because a lot of them are not written complaints and a lot of it.
And those ones that you're talking about, that someone makes a verbal complaint, they do an online one or something, those are almost always quashed because the sergeant looks at the video, everything's fine here, no problem, we're moving on. Or it's minor and it's handled with a critique or the evaluation, or it's egregious and it's validated, but you still don't know the well, that becomes a departmental complaint and it meets 614. A captain writes out the complaint, forwards it to the chief, and now we should go through all of this. We should investigate it. We'll go out and internal affairs will talk to that person and find them and bring them in, get them a statement from them. It'll generate a complaint, but nonetheless, it meets everything because the sergeant or the lieutenant that reviewed that video sees it and says, "This is serious." Writes out the written complaint, hands it to the chief,
Yeah.
and triggers it. So I think it meets that, and I think that's a good idea if you include that.
I think we should include it. And my concern is, again, is just with the things prior to that where the corporal or sergeant goes out to the scene and because they've asked for a supervisor and they're alleging, the handcuffing situation, and you immediately as a supervisor look at the situation, look at the injuries, and it's done right there in 2 minutes. We can't do that anymore per this, which is going to be exhaustive for the larger agencies.
It's a good clarification. At the end of the day, the policy is intended to guide what people are doing. And we want that to be very clear for them. So I think that's a good change.
I'm totally supportive because I completely agree with your paradigm. We get either somewhat dismissive complaints, nondescript complaints. Oh, I feel this kind of complaint. We review it prima facie, we dismiss it. 614 handles all of that. I love it. I'm in favor of it.
So where do anonymous complaints come in?
We don't do that.
It would
614 alleviates that.
And to his point,
I don't know about y'all's departments,
Well,
but in Dallas,
yeah, if an anonymous complaint comes in and internal affairs does any quick research on it, and there seems to be some validity, it can turn into a departmental complaint.
Right.
And now 614 is met. But if it's anonymous and seems to have no merit, it's up to the agency, but I think the agency, most of them, should move on from it. My opinion.
But if we had this in there, I think it would definitely guide them in that direction.
It's a subcommittee language thing.
No, it's pretty simple, I think.
I mean,
Let's knock it
I
out.
sent you the 2 sections.
I really
And then
think it's a good idea. Save us a lot of work.
We take a break and during the break and come back.
Quick question though, and I think I just,
You made a really important point on that definition. I agree with you. The misconduct has alleged allegations. It should all be taken out. That's not the way it is in the law. Because in investigation, you say investigate allegations of misconduct, not allegations of allegations, right?
Right.
It's captured there. That's the way they structured it in the law. Misconduct is an act, and then you have to investigate allegations of misconduct.
Okay, yes, thank you, because that's what I was looking at too, and that's also to Jennifer's point of like narrowing the field a little bit. Misconduct is not an allegation of.
Right.
Misconduct is a thing that happened.
But it is an allegation of untruthfulness,
Correct.
Yes,
That's correct.
But not of the other
but not of
stuff.
the others, correct? So we'd have to just put that in, specific allegations of untruth.
Very good catch. Very good. So we're gonna remove our alleged under misconduct, the very first word. And then it's also at the end of that first sentence. Are there any others? So those two. We'll keep it under truthfulness.
Jennifer, what, 614 what?
It was, the two I picked out was 022 and 023. Yeah.
The difference in those is you can't discipline without the written signed complaint. You
Yeah,
can't
just need
terminate
citation.
without
Yeah,
an investigation. Oddly enough, you can suspend someone if you don't investigate it, I guess. But if you're gonna fire somebody, you gotta investigate it.
All right, let's take a break and we'll come back and finalize that law inclusion. Good job, Jennifer. You saved my agency a lot of work. Of a state agency or the head of a fire or local law enforcement agency, the complaint must be, number one, in writing. Number two, signed by the person making the complaint. If we believe that if we require this and are still in compliance with the law, I'm all in favor. So that's the threshold question. If it meets the intent of the law, we can figure out where to put it, but do y'all agree that it meets the law?
Yes.
Yeah, because you can't do any of this if it doesn't, you don't have that, really. I mean,
and we've been messing with the definition of misconduct from day one. I think we've all understood that the misconduct needs to be narrowly tailored for the purposes of this policy. So to add that, I don't think would be a stretch. John?
I don't think it's a stretch. I don't think, one, there's anything in here that would prevent you from doing so. I don't think, because I think, as Chief said, you can't do any of this without something to go off of. If you have a written complaint, then that gives you a basis to start going down the road of investigating and everything that goes along with it. And I think that achieves the goal of the legislation without burdening unnecessarily administratively or otherwise departments and licensees without any marginal benefit to the public and to the regulated community. Bottom line is, I think you can put a written complaint prereq in here. I do think you can do that.
Where does it go?
She's wanting to get back to Houston quickly.
Is that the next part of the question?
It's perfect. Everybody else is satisfied that it's lawful?
So just define allegation in your definitions. An allegation is a written blah, 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 whatever it is. Make that a definition and go back to investigation. There's no just out investigate allegations that triggers go back to what an allegation is. It's a sign for.
See that?
Yeah.
Jennifer, what do you think?
Yeah, I mean, I think that might work. I mean, I don't know if there needs to be more discussion on that, like, because then there's other types of allegations, I guess, like internal complaints and supervisors that are just reviewing. I mean, all those would be part of it, but now that we're kind of picking out one type, do we have to then address the other types? Does that make sense?
It is. We could do that. So under the definitions, we have a new one, allegation definition for purposes of this policy on an allegation of misconduct shall be in writing and signed by the person making the complaint for in pursuance of 614-022. And then we can now contemplate the internal.
and that makes sense because in number 3, this agency shall investigate an allegation,
Mhm.
as it's defined there, of misconduct, as it's defined, that may result in suspension, demotion, or termination at the time they issue. And so it's only saying that those are the investigations you shall investigate. Up to the agency if they want to investigate other ones, supervisor reviews, things like that. If you want to investigate those, knock yourselves out. If you do, you got to meet all these requirements and file a summary and all that. But you don't have to. You only have to investigate one's allegations that are defined up here and that might result in suspension, demotion, all that stuff.
And I think that's the intent of the legislation, was to provide policy for those big ticket
And
things.
that's your point
Yes.
earlier.
Yes, that was definitely, it wasn't intended to be as broad as it was this morning.
And we want to allow agencies to have discretion. There's no discretion for the big stuff, but if my agency cares about whether I'm wearing a seatbelt, and Jennifer's doesn't, then so be it.
Exactly.
So let me just ask the question, not that I think that there will be or that it matters if there is. Do we see any pushback from the Royce Wests of the world?
Of course we do.
It's in compliance with other law.
I'm just thinking through
We anticipate that
the holes being poked.
And
on everything.
And it's valid, right? I mean, if you're starting with this, why not finish with the rest of it? But I think there's an argument to be made for dealing with the big stuff first, eating the elephant one bite at a time. And then if we see that this is not capturing all the stuff that we want Royce to first capture, then we can go back. But this at least is in the spirit of the, hey, agencies, you need a policy on this big stuff. That's how I would articulate it.
Any of these complaints that citizen makes and signs, right? So they write it, come to the person. Is it a sworn affidavit?
No. Ours is not required to sworn.
It can be.
Should it be?
Well, no, I don't think you can make it that. And I've run into that before. It just has to be signed. And the law, the 614-022 is clear that it just says signed.
Because the argument is we
No.
don't want to prevent or discourage people from bringing stuff to our attention.
That's right. And there's
We find out it's totally false and you have no recourse
We
to.
can't set ourselves up to effectively limit the number of complaints we get by.
and there's
providing-
no format. 614 doesn't require it be in a certain way it's done. The citizen can literally write it on a napkin, and if they've signed it, it's valid. And that, to your point, is just like that. And so, and I've run across that, because you get one that's signed and they've gone to great lengths and you watch the video and it didn't happen. It's outright.
Is there any proof of identification that this person who signs this says who they are? Wow.
I know, I agree.
You know, you got to get to a point where you got to have some validity on the person that's making the allegation.
That's part of our investigation. You have to determine, does the person, do they even have standing? We start there.
That's right.
Okay, so it doesn't prohibit any department from requiring the standing and identification.
Oh, gosh, not at all.
No, not at all.
Okay.
I just
It's
dealt with
better
them this week.
use- It's better use is when someone calls up and they're angry and mad, is to say, hey, listen, I appreciate you calling me, but I'm gonna need you to come in and write out a complaint. I need it in writing. I need you to sign it. Oh, you're not gonna do anything about it? Well, no, I will. I'd love to help you, but I need you to write that out and sign it.
Okay.
That's the best use of 622 for stuff like that.
Okay.
As we define the allegations, the first one up there is violation of law. Do we need to address anything with that as far as what an allegation would be? Violation of law? Like I get a citizen complaint, but how would we need to construe that? Or is it necessary to look at that, the violation of law part?
That's what I was going to earlier, and then we talked about from the beginning, how you want to scope that. Do you want any violation of law? And I think in this definition that's been submitted today, we have local ordinances, things of that nature. Technically, it's a violation of law. That which y'all want to include it in the definition. Obviously, it's up to the committee, but I want to go back to another question. Maybe it's been answered in regard to the allegation. It's almost a written complaint being a prereq to a required investigation. And we're thinking about, from the citizen's perspective, what about any other of these categories or misconduct
that could rise to this level? What does it, within the department, can someone, obviously they would have to write
All
the
the time.
complaint all the time.
All the
So that's, I'm just making sure that every angle is covered here.
It's pretty normal.
Okay.
But again, those aren't the problems. It's the agencies that don't investigate these things. I mean, in theory, he gets arrested for TWI in another county. I'm not gonna investigate it. I don't have a complaint. I don't have to investigate it. That by your definition.
Yep.
And that's the sheriff in the other county is gonna write it down and sign it and mail it to me.
It's no investigation if there's not a complaint. That's what the model policy says, right? Is that what you're-
For our purposes, though, if we get something like that, the chief will adopt the complaint and he'll be the one that signs up.
I'm not worried about your agency.
Right.
I'm worried about the chief that knows there's a custodial interrogation from the FBI. Doesn't think it's
If we
important
have
to write
the
it down.
policy, I'm not sure that chief's gonna change their practice.
And they would already be triggered by the E1 and all that as well, right? Because, I mean, they were arrested.
Not if they do it.
Well, if it's a DWI, they were arrested.
Okay, so under definitions, the proposal is we add a definition for allegation. Ours, the allegation definition has to contemplate a violation of law. It has to say that an allegation of misconduct shall be in writing. And it should be signed by the person making the complaint.
Question, should we just change? Should we define allegations of misconduct?
That's what we're doing, allegation. It'd be separate. So you have misconduct and then allegations of misconduct. Is that what you're saying?
I'm saying.
That's what he had proposed.
No, I
Yeah,
just said
so-
define the word allegation.
Right, by using allegation is a written complaint, a written and signed complaint of misconduct.
And my question is, can we just define allegation of misconduct? Because that's, instead of defining the two terms separately, define the phrase.
Oh, up here, just make it allegation of misconduct, period?
Yes,
Oh, okay.
just food for thought.
I don't see why not.
Because as we read through the policy, then we have to understand what the definition of one thing is and the definition of the other thing.
Yeah.
But if they're both together throughout
That
the
makes sense.
policy.
Yeah.
I don't know.
No, I totally makes sense. So it would say something like, instead of misconduct under bold, it would say allegation of misconduct, dash. For purposes of this policy, an allegation of misconduct shall be in writing and signed by the person making the complaint. Allegations of misconduct shall include a violation of law, and then all that other stuff.
Yeah, maybe it doesn't work. I don't know.
If it works, it works.
I think we're on the right track, and I think it's just a matter of degree at this point. Allegations of misconduct, a written signed complaint of misconduct, and go through the definition of misconduct included in there like that. Is that just what?
A written and signed
Yeah.
allegation of, and then violations of
Yes,
law.
exactly, exactly.
And then just to clarify, the violations of state laws or local ordinances, that would only apply if that violation is something that the agency may suspend for. Is that right?
Suspend.
So we're eliminating a lot of state laws, right?
Yeah, sure.
Okay, just making sure.
You get an ordinance ticket from
Right.
codes because you're weed behind your alley.
So, okay, so that's gonna be per agency's policy.
It's also down in section 3. It's listed.
Yeah, that's, I'm just making sure that these are all going back up to individual.
Did Dallas have more comments on theirs?
Uh,
I think they had some thoughts, recommendations, which were not issues.
They had one other suggestion. It's in a summary report. They added E. If an agency is unable to complete a report to TCOL in a timely manner or within 30 days after separation, the agency shall notify TCOL. Or if the employee is separated 30 days thereafter, that an investigation may against the employee or former employee is pending. Provide the reasons the report could not be completed in the time frame required and provide the estimated time for completion of the investigation and submission of the report. So I think that they're trying to address the 30-day issue, recognizing that
Yeah,
they
but
might
that's
not
been a
hit
big
it.
complaint that in mind, right?
However, the 30 days is required for 4522, right?
Yes.
So it's a good point, but
It's a moot point.
So it's basically 30, is it to the best, I mean, how would that be answered? Because that's been they complete it to the best of their ability in 30 days and put the summary report in?
Perfect example is the OIS. And it's a heck of a shooting, a heck of a mess. They resigned during the investigation. I only have 30 days to do an OIS.
you're gonna get a crappy investigation.
You're gonna get a crappy investigation.
Because
You're
I'm
gonna
trying
get
to
a
make
crappy
the,
investigation.
That's why there's a provisional hiring period, right?
Well, that's where the 30 days comes from, yes. But,
Mhm.
yeah, no, you can get an extension on 180 days, right? And you commonly do, but there's no extension on this. It's not there. Doesn't make sense to me.
But it's only, but it's only upon separation. So if it's an OIS, you're fine because unless you know for a fact that they're separating right off the
I
bat.
said that he resigned during the investigation. He's gone.
Yeah.
I have 30 days to do an OIS.
But 30 days from when they decide they're gonna leave, right? Like, so
He's gone.
it
He-
may
he
be an
resigned.
OIS and maybe, I mean, I doubt the next day they're gonna leave. But maybe 5 days later, they're like, I'm out. So your 30 days would start at the 5th day.
Ooh, thank you very gracious. Give me 5 days.
You got 40 days.
Good now,
You
right?
get 35 days.
Um,
OISs are easy, I feel like. There's the other stuff that people might line over. That might just have to be something that we live with for a little while till we can get it changed in the legislature, right?
Yeah, I mean, I guess in the investigative findings, you would state what you were able to do in that 30-day process and what you're, again, only upon separation. So the other part, the disposition doesn't really matter that much because they're leaving the agency.
Where I see this definitely being applicable, and I've seen this one in a previous agency, a previous life. The allegation is sexual assault of the adopted child.
Other stuff.
They're confronted with the allegation. They resign immediately. We now have 30 days. It's criminal. We're going to do a concurrent internal. By the time you line up all of those interviews, you're toast.
Because you want to complete your criminal first, right?
This is.
You do that in 15 days, you still got 15 left.
That's if it's in your jurisdiction.
Yeah, making it even worse. That's a good point. Thank you for bringing up a point at the moot point.
Our department.
30 days earlier.
Yeah, I mean, I think 30 days.
Dallas. Anything else on Dallas?
Yeah, there's stuff.
There's not.
No, nothing else on.
Another person that I sent for a review on 3B on the investigation. It says complete the investigation in a timely manner. What's that mean? We know that if they separate, you only have 30 days, but what if they don't separate? What's a timely manner? Because it says as prescribed by the commission, what's the commission going to say on a timely manner?
5 days.
You get here 5.
So-
That's it's an OIS, you get 7.
Y'all agree that that's problematic language as written?
But if they're not submitting it, because you're saying if there's no separation.
Right, there's no, there's separation. This says that the commission is going to prescribe a timely manner on completing an investigation. We even need that sentence. Why is that sentence in there? Is it coming from statute?
It's in the statute word for word.
But as far as the criminal side of it goes, we've got the 30 days defined in subsection C. Do we agree with that? Am I on the right track?
Yes.
And I think the administrative investigations, it's later than 30 days after separation, right? That's what it is there.
I would.
Go ahead. No, you go ahead.
Don't interrupt. I think that, really, well, I don't know, a lot of agencies set their policy and best practices. I'd have to look again what it is, 90 days, or what it seems, but civil service agencies got 180 take disciplinary action. So anything less than that, and we're running, I think we're running afoul of a statute. If we say that a civil service agency has to complete something in 90 days, well, they actually have 180 days by law to take some action. So I think we'd have to say that 180 days would be what would be timely. Anybody with that?
Here's where it doesn't make sense. In my beat and confer, I doubled the 180, so I have 360 days.
There we go.
So you'd still be able to do that.
But don't you
Easy.
still got you got 180 once you're notified.
I have 180 to complain, 180 days to dispose.
Yeah, so, well, so what we could put in here is 180 days unless
employees
a particular
separate
jurisdiction has something different. Because these are without, if there's no separation, so a timely manner, so we could put that at 180 days unless a particular jurisdiction has something, whatever that verb.
Well, Austin is not going to finish an OIS in 180 days. They have officers on administrative leave for sometimes a year plus.
Just like what best practices does, you'd have to, I think, now this gets wordy and everything, but you'd have to have something in there that if you can't finish it, you can say, I can't finish it, and here's why. All right, you get another 180.
They finished, they're waiting for something. They've done their investigation.
Same one at OIS. Your investigation is not done. It's your tox comes back. Tox sometimes takes 6 months.
Exactly. Waiting on ballistics, waiting on whatever.
Yep.
And we're talking about completing in a timely manner?
For someone who's not left the agency.
Right. Does the law say?
I mean, if you say complete their investigation, their investigation's complete. It might not be closed because they're waiting for district attorney or.
Kind of the line I was thinking about was completion versus closing. Like, I think the point is you can't just shove it under the rug because the person's gone or whatever. But that doesn't mean necessarily that you have to do a full-blown investigation. You can only do it to the extent that you can.
But it's not completed until I get tox. Doesn't go to grand jury until I get tox or ballistics. So what is a timely manner? Is, by the way, where it says that's prescribed by the commission, we're the embodiment of the commission right now.
And also, I don't want to get stuck talking only about OISs.
I agree.
Because there could be any number of reasons why somebody's being investigated.
I guess the adoption, sexual assault of the adopted child, was that not good enough?
Yes.
Wide variety in here.
All lived experiences.
I would say 180 is fair. I think if there's exceptions, then, just like in 143, they'd have to be worked out separately. I mean, they operate under 180 currently.
Yeah.
Like you said, I mean.
That's what I was gonna say. Who at T-Pole could give a waiver? Like if they couldn't get it done at 180 and they needed.
They're not even gonna know about these because these aren't the separation reports.
That's true too. We're not gonna know you went over
Guidelines.
180, until the person does leave.
Yeah.
And then what? The person's left.
I'm good with 180. Half a year to do an investigation. Y'all want to do that? Complete the investigation within 180 days, period.
That's simple. And when there's alibis or something like that, you can address those at the time. Yeah, sure, yeah.
So how'd you get 360? Did they not try?
That's
They
right.
got
Sign
some
waivers till someone tells you to stop.
Just agreed to 180.
Like
Oh, that's a good point. Say it again.
You're gonna want to put in there 180 days once you're aware of the allegation, because it could have occurred 2 years ago. So
Complete the investigation within 180 days after being notified of the alleged misconduct.
But then are we bumping up against 143 and other stuff that actually do control this?
I know it's,
That is.
that is 143. That just.
No, actually, it's not. 143 says it's the date of the incident. Unless it's criminal, then it's 180 days from date
That's
of
right.
discovery.
But on this, we're actually, so here, we're really just talking about completing the investigation. Because, so even if you had some misconduct that occurred, 200 days ago, you may still investigate it, but you can't take any action. You can't take any discipline, a suspension or above. You may still get it and write a reprimand and put it in files and be done, right? So here, we're just talking about, you still investigated it. So it just, you got to complete that investigation in 180 days. It doesn't matter when it occurred. I don't think we're really running against 143 because we're just talking about, hey, this occurred. You got to do an investigation. You have to have it done within 180 days. The officer is still working there, moving on. But you can't linger it and let it take forever. Get it finished whether because it may be an exonerated thing. So 143 doesn't really matter. There is no discipline. You've got to finish that out so the officer is not wandering around thinking, man, this has been a year and a half. What? Still worried about this or what?
143 allows me to get a waiver in certain circumstances. So am I now violating this policy that says 180 days, even though I'm complying with 143 that gave me the AG waiver?
Well, you are, and just like Stan's got through meet and confer, he's got more than 180 days. And I think we could probably put a clause in there unless, but like John and I were just talking about, if it's something like that, I mean, I think I can sign a waiver and I'll do that until someone tells me to stop. And then we're good. But again, we're not going to get this report because the officer's not getting left. He or she's still working there. We don't get this for a while.
Not going to give people waivers for their own policies. This is their own policy.
It's true.
This is
True
their
enough.
own rules.
And
That's where this all gets really confusing.
TJ's right.
Enforcement mechanism.
This may not be something necessary for this model policy because internal policy is going to cover this. I mean, and that's, if I'm hearing what you're saying, TJ.
Yeah, but your timely manner and your timely manner are different because there's
Yeah.
laws that already
But this
guide.
says as prescribed by the commission.
So can I just strike the whole thing? You said it wasn't, you said it was word for word in the law.
Yeah.
What's the law say? I mean, it's.
Yeah,
what's
where's
the
it at?
It's exactly what it shows right here in B.
But give me a citation.
It is 1701.4522B1B. That's complete the investigation described by paragraph A and
So we could set it 180 days and when agencies call up and say, hey, listen, I've got a meet and confer this says, then we can go, hey, you're fine. Just write your policy and you can.
Yeah, but I gotta explain to the community why I'm doing something different. Just because I called you and said it was okay, they're not gonna find that.
That's fair.
Okay, can we say 180 days unless the agency is subject to chapter 143 or other meet and confer, or something like that?
I think that's exactly, yeah.
Absent other applicable law, 180 days. Is that what we're talking about?
Yeah, that makes sense.
I think we use that language somewhere else in one of the other.
And really, that's kind of a blanket as well, too. Again, we're speaking, we don't want to step on the toes of 143, any of these policies and collective bargaining. Those control. This is again in the absence of any model policy whatsoever. Obviously, then the obligations to do the misconduct reports and things like that. But yeah, I think it's a good point to remember that it's globally applicable that in the absence of other controlling law, you've got this right here.
Can we also add, within 100 days, absent other applicable laws or negotiated agreements? Sure. That covers, meet and confer, it also covers collective bargaining.
That's great.
Okay.
I got a question. What about if there's a separation?
It goes back to the 30 days then, which is the very next.
Well, that's just, this is talking about completion of the investigation. Okay, yes.
Yeah.
All right.
And this is a non-separation situation.
Yeah.
We have no knowledge of what's going on.
Yeah.
The event you just talked about is when upon separation, and that's.
Well, but I actually agree with this point. So if you look at the totality of the policy, everybody's going to read that, hey, I have 108 days no matter what. The 30 days on the next C is for criminal. But if you have an administrative separation, or if you have a separation, it's administrative investigation, you only have 30 days to finish.
Yeah.
So we need an additional sentence.
So 'cause that's in the summary report, right?
And D. right?
Under, yeah, D. Yeah, those are for separation.
All right, we're good.
So if an investigation is still ongoing, and there is a separation, and we do get a summary report, an incomplete summary report because it's ongoing or there's an appeal or something, is there anything in this policy that says you have to come back around and close it out when it's done?
Just the appeal part.
But does it say anything in this policy?
If somebody, there's an allegation of misconduct, they work for 60 days, then they quit. Now your 180 days has gone to 90 days. The 60 you already had, plus you get 30 more, and then you've got to be done. The only way it wouldn't be complete is if there's some appeal, but that would have to, the discipline would have to have been administered before they left. And then you are. Most of these, the 30-day ones, will have no discipline attached because they quit prior to completion of the investigation.
And
It also states that the agency must notify TCOL 30 days after the appeal is, the disposition of the appeal.
That's what I'm asking.
Yeah, it's in there.
Thank you.
But those people did not quit under investigation because discipline was administered. Right? You can't receive discipline after you've separated. So there's two scenarios.
So the 180 days applies to the departments that don't have an agreement outside, meet and confer or something like that. That'd be like mine. We don't have anything like that. So we'd have 180 days.
It's what you have currently, I think, right? Or no? Yours go forever.
So yeah, that's helpful.
And it works well because so much of this is kind of making agencies align with the civil service rules that are already out there. Yeah, things in there. I like it.
All right, I think I have all of Julia's. I have Dallas's, Jessica has Dallas's. I have my own. Anybody else have any concerns on misconduct policy? Iris thought she could get us all these revisions by 5 o'clock today.
He's already got them done. What are you talking about?
Any other matters? This is 301.
Looking at Victor's. I think that ship has sailed with some of the changes that we've already made.
And I think his concerns on misconduct mirrored yours, but hopefully by including the 614 provisions will abate his concerns.
Yeah, he basically took the language right out of the bill and put it in, but the problem was it didn't address all of what we were required to do. Like, I agree with what he said in that policy, but it just didn't address everything we were tasked with doing, which.
Yeah, I like his less is more approach, but you're right, it doesn't. If it were as easy as cutting the bill and putting it onto a Word, we wouldn't have had these meetings.
All right.
I do have one for you.
Yeah, go ahead.
It's from the Rangers. It said, if there's an ongoing criminal investigation, would there need to be some type of prosecutorial approval to release the investigative file if it is still pending?
They wouldn't have to release the file.
Whole file that. Current protections stay in place.
Do you know why they thought it would be released?
It was reviewing the chapter.
So let's say the employee separates. We have 30 days. Are almost still ongoing. We're not going to give them any of that investigation. We'll give them the summary narrative that says criminal charges were filed or the matter is under appeal. And we wait until final adjudication and then we give you all the rest. Is that right?
One of your officers is accused of excessive force. You call in the,
Officers, yes.
she calls in the Rangers to investigate though. She'll complete her admin, do all that, but they won't have to disclose their criminal until it's complete the regular reporting requirements. It's that whole separate process. There's nothing in this that triggers an early release of the criminal investigator.
Captain Rice, anything from you up in the warm and tropical panhandle?
No, sir, I had several questions, but the rest of the committee members already addressed those.
All right, so the next steps forward would be for staff to provide us the edits for all three model policies. Jessica and I will then kick those to the rest of the committee. We'll review just on our own volition, provide any feedback to Jessica and I, and then we will contemplate your changes and then submit whatever we would agree to you all. You all also will try to get us before the rest of the committees, the presiding officers, before we go to commission. Agreed? Good. Y'all see a need to meet again?
I hope not, but if
I'm offended. Are y'all?
well, we've done good work, I think, but as we receive them, I suppose there may be an option, but I don't think so.
Or something if need be.
I think we've agreed to.
You can meet again, just not have another meeting.
I think we could take care of any last minute cleanup on all six electronically. Agreed? So I want to echo Chief Stevens' thanks for volunteering, because every one of you volunteered for this committee. Thank you for doing that. This actually has been a really good experience. I was sincere when I said that Jessica and I will try to tackle some level of education at the TPCA conference in March in Galveston, because I can tell you my peers have a lot of questions. I had a lot of questions. I still do. That's why I took copious notes. So thank you for making me a better police chief. Thank you for the relationship that I hope to continue with all of you. Comments, thoughts, questions?
No, I'll just echo that. I think we have and will continue to do good work. I have enjoyed these meetings. They've gone long, but it's really been interesting to hear the robust discussion and different points of view. So hopeful for the future, and hopefully these policies will do what we intend for them to do. Thank you.
And Chief, and then John, because you have the most consistency with the group.
Yeah, again, I want to say thanks, and this is important work. It's good work, and we got a bright future. Law enforcement's going in the right direction. And but I said yesterday, when people call the police when there's a crisis, they don't care if it's a constable, a trooper, sheriff's deputy. It doesn't matter. It's just people that step up and step forward and crush the hard problems of society, and they need good direction. And I think it's being provided, and it's folks like you that step up and it's not easy stuff doing this, and it takes a lot of back and forth to come up with what will hopefully be great guidance and everything that will inevitably need to be tweaked. But I really just appreciate everybody jumping in. So thanks.
That's fantastic. The work been done in this committee, the attention that you've all given and your time and your effort. This was not an easy lift in any stretch of the imagination. Any one of these policies would have been enough to occupy everybody's time and energy the last few months. Y'all handled three very in-depth topics with a lot of intricate details and wide-ranging effects. And it took everybody's input in this committee to get this done. And I think to have a product that is Chief Lamo discussed earlier, reflects the diversity of both the agencies and the regulated community and the public in here. So again, we thank y'all very much for all your input and certainly your work. We look to have that drafts back to you very shortly.
We look to have by the second week of February, probably February, I say the second week, probably around February 12th or so, we're going to get the finished product once we've had the back and forth to the commissioners. That will be presented to them. Obviously, we'll have, as we discussed, sometime in February, it feels like, having the presiding officers and APOs of the committees get together and see if there's any crosswalk that needs to be done with that, and have the first discussion in, we haven't finalized whether it's going to be at the workshop or at the commission meeting on February 26th and 27th. But I think we're going to try to accommodate something at the workshop. Again, that's something that needs to be discussed with the presiding officer, and we'll get back with you on that. But to give you all the timeline on that, that's the first presentation. There'll be the public comment period after that, after those get posted to the Texas Register for the entire world to see. And looking at April 29th through the 30th is once those have come back out for public comment, the commissioners will reconvene at the April meeting, look and consider any public comment that's been received, any further input that you all may have at that commission meeting. And the hope is to adopt those policies and any applicable rules for the other advisory committees at that meeting. At that point, hopefully we'll have all the forms and everything like that finalized. And during this whole process, we'll discuss with the commissioners, and this is something input from you all as well, is looking out forward to that implementation, when that's going to be, September, January, whenever the case is, for the entire law enforcement community in Texas. So that's just the general guideline and the timeline that we're looking at between now and April. Obviously, after April, assuming everything goes smoothly and the model policies are finalized, we've got a long, effective, communication and education period that we've all discussed, and obviously getting the IT infrastructure tailored to the model policy, and then we'll have an effective date somewhere in the near future. So that's the outlook moving forward.
What you overlooked was we were the best committee.
Well, I didn't want to say that.
Just know it. Hey, on behalf of all of us, I want to thank you as an interim director. You were phenomenal. You did a great job of stewarding TCO through a remarkably tumultuous time. And so I know some of us had insider seats on that, and I appreciate your leadership and your stewardship. I think you've done a remarkable job. I'm thankful that you were staying on. I haven't been told otherwise. Hopeful that you stay on with TCO.
Please.
Just know, sincere thanks, good leadership. Anything else?
I have to say, from labor side, since we're the labor, we do appreciate it, that management listens to our concerns and sees it from our standpoint. And then for the TCO staff to understand and try to put it together, the two sides. And I think we actually did really well. I'm a little surprised. Wasn't a lot of arguing and screaming, because you guys are very reasonable and understand our difficulties and problems as officers and who we represent, what's going on, because it affects their lives. This affects their lives daily. Management sometimes doesn't see it, but I think y'all understand that we tried to bring it to y'all and show you how this affects officers and all this with the times and everything like that. So we appreciate it. I do.
Well, and I think the beauty of the committee structure was you sent it to DPD and asked for feedback. They raised the 614 concern. You two already had the 614 concern. You're a dog with a bone when it came to 614 concerns. So you again appealed to the definition of misconduct. And I think we actually have a pretty good product that's consistent with another arm of law. That's the beauty of this committee. It worked. Now, having said that, we're going to be the scourge of the earth when we leave, because when they see this, they're going to be like, what the hell did that committee do to us?
Oh, yeah.
To which we all say, yeah, we try to work with TCO. You know how they are. Break. Thank you.
I think we have to adjourn.
Oh, we need an official motion to adjourn.
Public comments.
Public comments. Are there any public comments? There's nothing from SUPPORT?
No.
Support in the corner. All right, I hear no public comments. All right, we're ready for a motion to adjourn.
Moved.
Second? All in favor, say aye.
Aye.
You're adjourned.